Angelique, come on. Okay.
Earlier they could hear us through the mic. Good morning. Can you hear us?
Can you also see us? Ah, nice.
But they can't smell us. Good.
About it.
I stop.
Now is it? You want to add the entropy?
Hmm?
You want to add some
That's
entropy?
yeah.
It's long. Okay. Good morning, everyone. Thank you very much for being here. Those who are here with us in the room, those who are online, the speakers and the experts involved in this project. And thank you for the attendance, all the participants who are online to attend this event. We are very thrilled on behalf of the ETUI to hosting this event, to hosting this exchange of views and expertise and discovery, in a way you can say. This meeting started conceptually as a book workshop because more or less a year ago, Wouter and I started this project. We try to involve experts. We are actually very glad and satisfied with the turnover from experts we received. We didn't expect such an amazing lineup of professors and scholars joining us in this project. The idea was to compare, map, how industrial relation practices, social partners, trade union were addressing the issue of the integration of AI and algorithm management in the world of work. So conceptually, everything started as a mapping exercise. Then we found out the mapping exercise difficultly are exhaustive when everything is in evolution and movement, and it's difficult to just pinpoint reality in one moment. Therefore, we decided to also contextualize this exercise in a broader context and identify challenges, obstacles, good practices in which we can actually assess, through which we can actually assess the initiative that the expert discovered eventually in the country mapping. This is a multidisciplinary project, and today we are presenting the preliminary result. The preliminary result of these country studies. And before I move on, I'm giving the words to my colleague Wouter and to the STEAM expert that are with us today. I would just like to give a few words on the motivation behind this endeavor. Of course, the ETUI is not the only research institute addressing AI at work. Many of those who are here in the room started this exercise years ago. So we are trying to connect a bit the legacy. But why I think why we think trade union institutes are very well positioned and have the urgency to do so. So first of all, we need to acknowledge that digitalization, AI, and algorithmic management are a huge trigger in the changes of the world of work. They are, of course, affecting labor market trends. They are affecting working conditions. They're affecting the managerial power and competence of employer, contractual employer or de facto employers. These trends contribute to blur notion of autonomy, independence. They aggravate labor market fissuring, fragmentation. So these are all issues that add to the chaos that unions have to face with when they try to protect workers. Even more interesting from a macro perspective, they aggravate power imbalances. We are seeing companies that, because of their expertise and proprietary right in technology, algorithm management, AI, and data, they have a competitive advantages vis-a-vis other competitor. And therefore, this creates an even bigger asymmetry between labor market power within countries or a broader region. So this is why it's really important, of course, and crucial that not only scholars, but also, let's say, activists and above everyone, unions engage on how to reconnect workers with their collective power in situation triggered by digital technology. Now I would like to give the word to my colleague, Wouter.
Hi, I'm colleague Wouter. I'm also a researcher at ETUI, and I want to just thank everyone as well for being here, for attending online, and also specifically to the authors of the country chapters for the excellent work already done. And I think everyone will enjoy the talk because it's really, really interesting, the different country chapters that highlight what's happening in terms of collective bargaining on AI and AM. I could read it if my eyes were, but so just this is briefly talking about digitalization, automation, and labor, which is of course not a new topic. That's a bit why we're highlighting it here. We're talking now specifically about the newest iteration, artificial intelligence and algorithmic management, but there is a long-standing area of research on what happened with previous ways of technological innovation and change, how this affects work and especially the conditions of work. That's where a lot of our insights come from. And I think there as well, one of the things that are really clear is that the more workers are engaged and included in the adoption of new technologies, the better outcomes tend to be. Because I think it's also very important here that we don't be too negative about AI and algorithm management, especially AI. Algorithm management is a bit different, but there are a lot of there's a lot of positive potential there as well. But the main issue is how is it implemented? How does it affect the power balances, like Sylvia said? And there it's particularly important that workers are involved, which also tends to give better outcomes when adopting new technologies. So when we're talking specifically about generative AI, deeper involvement of new technology and algorithm management, this potentially affects a very large workforce, which is also why we're talking about it much more. The estimates still range very much because we don't have very clear data yet. But in a recent OECD survey, they came out with about 90% of companies using some version of AI, and 78% in European countries. Of course, this is not all as widespread or as in-depth yet, but there's no reason to think this won't just be expanding across the labor market in the future. What is also coming out from the different surveys that are being carried out is that there's still a lot of uncertainty on behalf of not just workers and trade unions, who sometimes feel a bit unequipped to deal with new technologies and especially the generative AI and the automated decision making, but also by managers who don't always know exactly what happens to the data, are not always aware of the rights and obligations they have. And so this is still leaves a lot of scope for vulnerability and negative impacts. We also know from studies that to the extent we can already say something on the impacts, it's a bit double. So there is higher productivity for people who use it to some extent, but growing intensity of work, the surveillance can have very negative effects. The question is also what sort of jobs are being complemented, affected. It could help by taking, if you're looking at it in an idealistic way, it takes away the monotonous, boring parts of work. On the other hand, it might also be that you're just stuck with the monotonous, boring parts while the more creative things get taken away. And it could be reducing autonomy. So the main question is we don't know yet, but it is quite important how it's implemented. So when we look at the literature and especially on previous waves of technological innovation, we see that workers' representation is particularly important when it comes to adopting these technologies. And when they are being involved, you tend to have better outcomes in terms of productivity, retention of workers, and the like. So, of course, this is not an unregulated area. There is EU regulation, which Sylvia will talk more about. But when you're reading a lot of the papers, what is coming out is the need for workers to be involved for collective bargaining, but we don't have much data yet or much information on to what extent that's being happening. So there have been some projects, there's some very interesting work in the service sector, for instance. But what we're lacking is sort of overall overview of whether collective bargaining is already engaging and whether the social dialogue is taking these themes on board. And that's really where this project comes in and where your chapters are a very important contribution. So back to Sylvia.
Yeah. So indeed, transnational initiatives have happened, not only on the purely regulatory landscape. We know perfectly the existence of the AI Act, or more recently the Platform Work Directive, and the applicability of the GDPR under certain circumstances to the world of work. But that's not it. As we are talking about social dialogue, there are also since a while, European social dialogue initiatives. The broadest framework is, of course, the European Social Dialogue Initiative from 2020 on digitalisation, that preceded many of the trends of remote work and a stronger integration of AI. And then we have quite interesting sectorial initiatives. The most recent one is in the banking sector. Those more recent initiatives, they really dive in on AI. Sometimes we have definition, not always compliant to each other. We have definition. We have a very strong stance on data right. And the use of technology is shown to be quite an economic asset in the end of employers. And therefore, there are some acknowledgement on how to tackle that. Quite interesting also that we found a declaration from the Labor 7 and Business 7, which are the representative of social partners among the G7 countries that during the last G7, they call for fair AI regulation. So there is quite a mobilization in theory, no? We also found, we just mentioned a couple because they were not fitting more in the slide. There are also quite a lot of private initiative of global framework signed by multinationals and the World Council or trade union at international level. They started addressing data and technology quite in connection with the COVID, with the pandemic, because remote work was more common, and therefore there were some initiative. On AI, we didn't find as much. So obviously there is an interest, but here is where we want to look at the country level to understand to what extent actually the national social partners are able to engage. And this comes indeed on the introduction reel on the pragmatic aspect of this project. So here we are talking about collective bargaining AI. We decided to launch this quite broad in a sense. We cover 8 countries. These 8 countries represent some of the biggest economy within the EU. They're quite diverse. So we have France, Belgium, Spain, Italy, Germany, Poland, Denmark, the Netherlands. We asked the expert to cover specific sectors in particular, if possible, but also to have an overarching view on the whole national economy. The specific research question that the expert have addressed is basically try to understand to what extent is AI and algorithmic management addressed during industrial relation practices, and to what extent is the labor law framework conducive of interesting practices coming up? And if so, what are the thematic areas that we find to be regulated? Yeah, so we'll give the word to Wouter for the last data part, and then the expert take the word.
Yeah, this is just a very last setting the scene. Talking a little bit about the countries we've selected and variation across the EU. This is all data. That's a little bit of an issue with much of the data sets we can use. This is from 2019, so before the COVID pandemic, from the European Company Survey, which is one of the Eurofound surveys, where they asked companies and company representatives to what extent different types of technology are being used in a company. And here it's about software data analytics, which is also used for monitoring workers. And the main thing I want to highlight here is the variation you see, with Southern Europe a bit higher, for instance, Spain, Italy, also Romania, and then France, as in many things, somewhere in between, with Germany a bit lower. Then this is slightly more recent. We're slowly coming towards current times. This is from 2021, from the European Working Conditions Survey, another Eurofound thing. And there they asked people to what extent they're interacting, so workers, to what extent they're interacting with a computerized system at work. You can see this is much higher, but of course a computerized system is an incredibly vague term. And for highly educated workers, it reaches almost 100% in most countries. So we're getting some variation here. Again, we do somewhat see relatively high in the north and south, a bit less in, for instance, Netherlands, Germany. And then the latest data we can use is this Eurobarometer from 2024. Now, this is always somewhat less reliable than the bigger surveys, but it gives you some indication. For an inexplicable reason, I've chosen a completely different color scheme here. But so darker blue means more intense. And again, we see Spain, Italy, Romania stand out. Poland and Belgium also somewhat darker blue. and a bit less in Germany in terms of whether workers reported that any sort of AI or new technologies were used to hire workers, to allocate tasks to workers, to manage schedules, to monitor their activities, assess their performance, or enforce safety. So all different aspects of essentially algorithmic management or performance management. Then I just want to highlight a little bit the 8 countries we've picked, and from which we have the excellent experts, or at least one of the team sitting here, or being available online. So as Sylvia said, we tried to get some sort of, as Sylvia Arnona said, we tried to get some sort of spread across Europe, but also we have quite a big variation in terms of the industrial relations system, which is important for this aspect. And then in terms of this prevalence of algorithm management. So in this table, I just want to focus a little bit on the variation in union density, for instance, and collective bargaining, where we're ranging from Poland, which is very low union density and very low collective bargaining rates. This is from the OECD data, which is not always the most reliable, but there is at least some way to compare countries. So this puts Poland at about 13% collective bargaining coverage rate. And then we go up to Belgium, France, and Italy, where we're talking about near universal. But of course, big variations in union power and in the way the collective agreements are covered and in the content of collective agreements. We also have variation in the level of bargaining. Poland, again, more at the local or company level. Many of the other countries have some variation. So Belgium is more central and sectoral. Most others have some form of sectoral variation bargaining, but also with company levels to add on this. And then if we're looking at the prevalence in terms of the Eurobarometer, what I showed, we have very high levels of workers reporting some experience or some exposure to this form of algorithm management in Belgium, in Italy, middling in Poland, and then somewhat less in Germany and the Netherlands and France. This is not the same as using the AI. It's really about the management part. So I think with this, we stop the introduction and we can start directly with the different country chapters, which means I keep talking for a little bit because unfortunately, the Belgian colleagues, Dirk, Valeria, and Caroline were not able to make it today because of health reasons. And as the nearest Belgian, I was asked to, to substitute. No, I wasn't asked, but I volunteered. Put this in. New system, how do I? Yes. How do I put this full screen?
Help without any competence.
You're coming to help?
Maybe.
No, it looks better if both of us are. So just an introduction while my IT person fixes this and puts it in full screen. This is a chapter prepared by Dirk Gillis, Valeria Pelignano, and Caroline Leenaerts on social dialogue, collective bargaining in the context of Belgium. We thought this was a really important chapter, and also we thought it was interesting for the next discussions to have some indication of the findings of this chapter so we can compare afterwards, which is why I'm giving an interpretation of the report so that we can highlight the main facts. Of course, this will not be as detailed or as good as if they had done it themselves. And very clearly, I made the slide, so if there are errors, they're very much mine. It's an interpretation of the report. So first of all, we won't do this for any of the others. All the other people present their own reports. So first of all, as I showed earlier with the overall introduction, Belgium is characterized by quite a high digitalization. Also, if you look at other surveys, there's quite a high use of computerized systems. There's a high use of AI already at work. And there's a high prevalence of AI and to some extent algorithmic management. There's also, it's quite alive in terms of the societal debate, in terms of what the social partners say. Can people hear me? Oh, they should see me in all my glory. If I stand here or like this. So it's we have a lot of debate in terms of social dialogue and the social partners. There's a lot of reports coming out, which I'll talk about in a little bit, from the National Labour Council every year. There's a lot of follow-up. But what's not really happening is a translation of this sort of overall debate and social dialogue into actual agreements. And where it happens, it's mainly because there were some regulatory changes, legislative changes that gave the impetus and the push for this to be taken on in collective agreements. The reason I'm highlighting this is because this came up in some of the other country reports as well, that the way in which these topics find their way into the collective agreements and collective negotiation is often relatively top-down, that something happens at a regulatory or legislative level, and this finds their way into the negotiations. And that also means most of the time the topics that are being discussed are relatively traditional collective bargaining topics like wages, working conditions. So I'll give a very short introduction about the industrial relations system in Belgium, which is well established. So as I showed earlier, we have very high collective bargaining coverage. We also have quite a high union density and very high employer density. So social partners are, one, quite powerful and present, and two, quite active in the collective agreements and collective bargaining in a very hierarchical system of collective bargaining. What happens at the national, federal level and regional level has sort of echoes of this, but I'll focus on the federal, is that you have the National Labour Council, which advises on social and economic matters, and they bring out these reports on digitalization AI also from time to time. And there you also have the arena for negotiation at the highest level. It's called the Group of 10, even though there's 11 people present. No one really knows why, but this is the top representatives of the trade unions and of the employer organizations. These are not binding agreements, but they generally do get carried over into the collective agreement. So that's the highest sort of level, the political steering. Then the actual collective negotiations that happens in the sectoral committees. These are called joint committees or paritaire comités for everyone who's familiar with the Belgian system. And this is where the binding collective agreements happen and where we have some examples also. Then at the company level, when a company is big enough, there's generally some sort of trade union representation, but also there's an obligation to have from 50, I think it is, a committee for prevention and protection at work. And if you're at least 100 employees, again, I think it's a works council, which have somewhat varying powers, but the Committee of Prevention and Protection at Work takes over the works council powers if there's no works council. For these, we have elections every 4 years, the social elections, which those of you who are fortunate enough to work in Belgium from time to time probably have taken a part in. And a crucial part here is that the unions have a very protected status in this. They're the ones who sit in these committees, and essentially they have a sort of, it's a bit more complicated than that, but they have a sort of monopoly on the bargaining and the negotiation. So now let me talk a little bit more about the meat for the aspects of the new technologies. So what's highlighted in the report, which I found very interesting, is that there was one at its time, but this is 1983, really pioneering and important collective labor agreement on information and consultation regarding the social consequences of introduction of new technologies. This is in theory still valid. So what this essentially says is that if new technologies gets introduced at the workplace that will have some impact on the employees, this is social consequences or collective consequences, and that has generally been interpreted rather widely. So this is about work organization, working conditions, or employment. And also it doesn't have to be a new technology, it has to be new to the context, so new to the company. They have to provide information in writing and consult. So it goes beyond just information, there's also some consultation and discussion needed. The practical relevance today, as the authors highlight, is minimal, but it still gets mentioned in the collective agreements to kind of give an update of it. And this is something we wanted to discuss with you as well, because in some countries, I think in Denmark, this was to some extent the case as well, that there are relatively encompassing powers already to the worker representatives in these committees and these works councils to deal with new technologies, which might make it not necessary to have new collective agreements. And that might explain why in some countries we see relatively little. I don't think that's necessarily the case here. It seems more that they're running a bit behind the facts and we might be seeing more, but that's just something to highlight here. Everything's still clear so far? Good. I hope I'm doing justice to their work. So then the methods they used to look at the collective labor agreements is that they looked in databases and on the internet. So as a lot of you did, it was essentially a wide search because there wasn't a very clear database available, but they pieced a lot of things together. They also did consultation of stakeholders and experts and looked at the reports and what was referenced in there. And that gave them quite a big volume of collective agreements to look at. And then they checked whether there were specific provisions on the introduction or deployment of algorithmic management systems or artificial intelligence. And that was really easy because nothing referenced algorithmic management, not a single agreement. AI, a little bit more, there were 5. 2 of them were in the insurance sector, 2 of them were in banking, and 1 was in an additional joint committee for blue-collar workers. And where this was mentioned, it was generally mentioned quite vague, as in this is something that's affecting the sector, needs to be studied and discussed. And it's taken as a willingness for dialogue. So there is at least an overture for discussion, but there's no real commitments or anything coming out of it. The banking a bit more, they focus there on training and the needs for skills and to offer training. Then, as several of the other chapters have also done, because there was very little on AI AM, they widened it open a little bit more to digitalization in general. Then you start finding quite a lot of agreements on especially remote work, hybrid work. And then you come into the issue of the right to disconnect and everything related to that. So they highlighted some useful agreements here. There was a collective labor agreement in cleaning with a framework protocol on digitalization. This again was something somewhat top down because there was discussion regulatorily about this checking in at work, which also has to be done in the construction sector and several other sectors. And this was then taken on in the cleaning sector as well. And they went a little bit beyond this. The discussion was mainly about whether people would have to use their personal tools or equipment to do this checking in at work for the digital issues and for their work. And there was a section that employers would have to provide the tools, the devices. There was a section on the data rights. So here they went a little bit farther into the privacy issue, the data rights, and the tools and devices required. There's some training as well for these equipments. They also mentioned the digitalisation framework protocol in the family and elderly support services sector, which was about modernizing the administrative workflow. So again, more things digital, more of the management also through an app and digitally. And they wanted to focus there specifically on the data privacy, the protection, and they also, under the push of new occupational health and safety rules, which were also going at the national level, they focused on psychosocial risks, including a test phase if there was a new, rollout of these issues, and with the results reviewed in consultation. So again, this goes a little bit further into testing new rollouts and to evaluating them. And what they highlight in their study is that often these changes, even though they are happening, they're catalyzed by legislative change. They also mentioned that in terms of social dialogue and discussion, there are several reports from the National Labour Council evaluating the use of AI more generally, discussing digitalization. So there is quite a lot of activity happening, but not a lot really binding or in the collective agreements. And that's essentially the conclusion. So some issues relevant to AI and algorithm management and why the digitalization are being discussed find their way into negotiations. There's definitely some attention to it, but this relatively little attention stands in contrast to the growing prevalence of AIM. So if it needs to be covering all the workers affected, there does need to be a speeding up. Generally, when there are moves ahead, they come after regulatory pressure or regulatory changes. And there is a wider discussion in the field, but it doesn't find its way yet into the collective agreements. So they see much scope for unions to improve their involvement in this. And I will stop there, and hopefully we can discuss later with Dirk, Valeria, and Caroline whether this was more or less what they had in mind and what they found. And I hope this was somewhat useful. And now we can move to the next country study. Thank you very much.
Thank you, Wouter, for this clear overview. So now it's the turn of Anna and Nathalie presenting the Danish case. So the floor is yours.
Thank you very much. I will just share my slides. And we will see if this will work. And there we go. Yes.
Perfect, we see it.
It's always a little bit. Okay, so thank you very much. Thank you very much for inviting us to be part of this interesting project. And also thank you very much for organizing this seminar. I'm sure it's going to be a day full of really, really good insights and inspiration for all of us. So we're going to present on the findings from our study on the role of social partners in Denmark and the use of AI and AM. As just for a small context, Denmark is this tiny, tiny country up there. There's 6 million inhabitants. On the labor society as such is characterized by high adherence to the rule of law. We are #1 in the World Justice Project, and also that the Danish model and flexicurity sets a very good framework for everything that happens in the labor market. We have a favorable economic climate at the moment, a low unemployment rate of 2.9%. It has been steady for over 17 months. And we have 3 million people in employment, which is not a lot in total, but is a lot as a relative number, right? In Denmark, we love digitalization. We really, really like digitalization, and we want more digitalization, and we want more use of AI, and everybody is playing with AI at the moment. This high degree of digitalization in society has been driven by a high digitalization in the public sector, where citizens and companies are motivated to digitalize, and actually more than 90% of citizens and companies interact with public authorities digitally through online platforms in Denmark. And this means that it places us sort of at the top of this DESI index. I know it says it's from 22, but it's the latest one available, where we are up there along with just next to Finland, which is, I think, a great achievement. So, but it's also widespread in the Danish labor markets. Surveys reveal that workplaces in Denmark use digital technologies a lot. Most Danish workers use computers, tablets, or smartphones, with 82% using them on a daily basis, and with 50% of them using most of their work time on digital devices. All of this has also, there are many political agreements in this area, and the latest one is from February 24, where there's an agreement about an ambitious and responsible strategy for Denmark's digital development. There's an entire section allocated to the use of AI, where the purpose is that the use of AI must be accelerated, and Denmark must set an ambitious and responsible direction for the development of artificial intelligence, and this will contribute to increased productivity and release resources for more welfare for the citizens. So that's sort of a context of where we are with digitalization in Denmark. When we just a little bit of context on the labor market, as we already heard, Denmark is the labor market is characterized by the Danish model, which means that collective agreements, is the preferred tools for not only establishing the actual material working conditions, but also the framework for industrial relation. And this means that agreements are the tools that establish who is a trade union, who can conclude a collective agreement, what is the framework for lawfulness of industrial action, so the interaction between the social partners, as well as the material working conditions for the employees themselves. This is legitimized by a high high unionization rate, democratic legitimacy of leaving this in the hands of these private actors is legitimized by this high unionization rate as well as a high coverage rate. Of course, legislation also plays a role, but as a supplementing setup. But even when we do legislate, the first step is to engage in tripartite negotiations. This is seen as the better way to ensure that legislation aligns with the interests of workers as well as businesses, and also to educate the legislators a little bit on how to find the good balances. This happens, tripartite negotiations happens all the time, regularly, regardless of who is in government. It is a preferred tool, and it is with worker representatives as well as employer representatives as colleagues in finding the better ways to do this. So this means that legislation is supplementing material legislation, but it also legislates on fundamental rights such as freedom of association, and there's a legislated enforcement system as well as dispute resolution system within the Danish judiciaries, like the ordinary judiciaries as well. Okay, so with this, it means that we have a central role for the social partners. This central role and this sort of wide flexibility put in their own hands means that it enables the labor market parties to address new developments in the market. It also is voluntary. We don't have erga omnes agreements or legislation that says that you have to follow a certain collective agreement. It's entirely voluntary. This means that bargaining is central and collective action is central. There's a wide, it's widely protected, the right to strike and the right to lockout. And when an agreement is concluded, it is then binding on the employer, and breach of agreement is sanctioned by harsh penalties in a fast and smooth industrial relations dispute resolution system. So with this, when we then talk about what goes on with AI and AM, we have already a number of existing agreements where AI and AM already fits very smoothly. First of all, we have binding rules on how to use monitoring and control of employees. The principles were established already in 1913, and they are now also codified in binding collective agreements on control and monitoring of employees that are concluded at confederation level and applicable in all of the private sector. But also, since 1899, when the first collective agreement in Denmark was concluded in the September Agreement, one of the clauses there ensured that there was a prohibition of abuse of managerial power. And this prohibition of abuse has been nuanced over the last 100 years in case law, meaning that any management decision has to have a just cause, and also that there is a principle of proportionality for management decisions, regardless of what type of decision it is, also when you use AI and AM. Another existing agreement is, likewise what we just heard from the Belgian presenter, that since 1981, we've had introduction of new technology in our cooperation agreements. The cooperation agreements mandates establishment of a dialogue between worker representatives and management representatives at shop level. And in this cooperation committee, there are a number of mandatory topics that they need to discuss. And one of these topics is the introduction of new technology. Not only do they need to discuss it, it's not only information, it's also consultation, but the cooperation agreement sets out the principles that must be used when you introduce new technology. It also has a special focus on retraining and upskilling of employees as a result of introduction of new technology. These agreements cover already 80% of the labor market. Very few companies in the private sector are not covered by these cooperation agreements. The original aim, of course, is to address the introduction of automation and robotization in the production industry. But of course, when we talk about use of algorithmic management, you could say, and the use of AI for that, you could say that it's a new technology. Also, when it is used to replace HR functions, not the manual labor, but actually the HR labor functions. So there's a great potential in this. It's right there, ready for the using. Any kind of you could say that it's inspired by, or it has inspired also the European Framework Agreement on Digitalisation, which has sort of a model for how to do this at shop level. But also we've had specific collective agreements with highly digitalized companies that use AI. We've had 4 overall strategies, and I'm not going to tell all of you. One of them is tailor-made shop level agreements. Another strategy is accession agreements to existing white-collar workers agreements. A third strategy is to use the temporary agency model. And the fourth strategy was to conclude a sector agreement in 2022 for the food delivery sector. But what we're going to talk about a little bit here is what has happened in the tailor-made shop level agreement for highly digitalized company. Because that's where we've made the biggest steps forward in relation to AI and AM. In 2018, this small Danish company called Hilfer, it's a company that makes a Danish platform company that works with cleaning in private houses. In 2008, they started by some Danish guys, and it's a great Danish success stories and how to find a new sort of platform in a new market and so on. Lovely. In 2018, they concluded a collective agreement with the trade union for the called 3F. It's the largest trade union in Denmark for skilled and unskilled workers, and they cover cleaning. They clarified the status of their cleaners, their default employee status, and they also clarified a number of material rights for the employees that sort of mirrored or resembled the existing rights in collective agreements. So far, so good. In 2024, the parties managed to agree to an upgrade of the Hilfer agreement, the Hilfer 2 agreement. In this agreement, in addition to what was already established, they had a number of sort of clarified or new rights, aligning more the agreement's material provision with existing industrial relations in Denmark, a lot of references to the main agreements in the area and so on. But also they introduced new provisions on fundamental rights and also a new chapter on AI and AM. And those are the tools we're going to take a little bit closer look at. On the chapter of fundamental rights, we have a few sections that are interesting. One is that they established what you could call a digital clubhouse for the workers, for the cleaners. The trade union was allowed to put a link on the Hilfer's website for the employees to use. When they followed this link, they were put on an external website hosted by the trade union where the employees could exercise their collective rights. They could elect representatives who could or discuss issues at the workplace. And this clubhouse is available for all the employees regardless of their unionization status. Another advancement was that Hilfer promised or guaranteed to make sure that workers were not discriminated in general and were not discriminated in particular because of their unionization status. That Hilfer would make sure that there were no hindrances for the full engagement of their labor, that the unionization status would not be used directly or indirectly as an obstruction for being able to make as much work as possible with their workforce. And also, of course, everything on good working, safe and healthy and working environment and well-being, as well as non-compete clauses were introduced. But of course, these two ones are addressing specific risks when you use AI and AM, and in these highly digitalized models that are depending on the use of AI and AM, to try to introduce novel ways to ensure that these fundamental rights are still able to be exercised also in these types of companies. When we look at the chapter on AI and AM, this is now in collective agreements. First of all, a right to information about the use of AI and AM, a right to challenge AI-AM decisions, and a victimization clause if you are challenging a decision, a right to written reasons for unfavorable AI-AM decisions, a full statement not only of the reason but also of the facts, the assessments, the weight it's been given in the considerations. Failure to give the written reasons means that the decision is null and void. and also a provision on transparency on data, transparency on where algorithmic decisions are used, transparencies on when algorithms are processing data or making calculations that are then used by human decisions, and also transparency on which data are collected from the platform and from which sources. When we talk about data, there are a few provisions on data protection. One is that any processing of data requires professional purposes, that the data can only be collected by Hilfer.dk and not by third parties, also cannot be transferred or processed by third parties, except for the tax authorities. And that the app that has to be installed in the private devices of the workers, the app has to have a setup so it cannot collect data from the private device except the data that's used for communication purposes with the platform and the employee. So no harvesting of data everywhere in the workers' private devices. The employee's online profile is protected. The employee has a right to rectify or remove false content. And finally, if data processing and further data processing is necessary or wanted by the platform company, we know that individual consent is a little bit dodgy, as looked at with skepticism in employment relations. So they have provided an approved consent form. So you can only approve to this type of data when you use this approved consent form. So that gives flexibility for the Hilfer.dk, as well as a certainty for the workers that everything goes on. It's been approved by the trade union. So with this, which is quite a significant advancement, I have to say, for actually putting AI and AM into a collective agreement that is binding. And this means that AI and AM not only is public rights, but it's actually individual rights that you can pursue against the platform company. So constructive trends on this is, first of all, that the Hilfer 2 agreements shows that the main arena for developing this is in the highly digitalized company. We don't see so much in other kinds of sectors, but we see it very much so being innovative and entrepreneurship with regards to finding good solutions in the highly digitalized companies. When you put provisions in a collective agreement that perhaps would apply anyway, like health and safety working conditions would apply anyway, and the right to engage in collective action would apply anyway. But when you put it in there, it means that you engage the entire industrial relations system, and it comes into the hands of the trade unions also for enforcement, which is a great advancement. It also clarifies for the employer that it is perfectly all right to use AI and AM for these purposes, and it clarifies for the employees that everything has been checked, and checks and balances are in place, and they can safely work under these working decisions. Yeah, and finally, it's made sure that only major changes to the business model means that the agreement has to be renegotiated. Not any small adjustments kind of invalidates the agreement, which means that it's also sustainable for a long time in this sector. So just looking at emerging gaps and challenges, quickly rounding up. One thing that is a takeaway is that this has taken place only in the platform work sector. So it's both a good thing, but it's also a gap. We haven't seen AI and AM addressed so clearly in other sectors. We don't know yet whether the platform directive or the Hilfer 2 agreement will have a spillover effect in other sectors, or whether it will be limited to this sector. Second of all, this development takes place only in bargaining with Danish-owned platform companies. We have no success yet with other companies. And also the bargaining have been taking place in an atmosphere of constructive dialogue from both parties. We haven't used collective action yet. And there's this sort of a little bit of a stumbling block in Denmark, at least, where there's a disagreement between the competition authorities and the Danish labor market parties on how to the extent of the coverage of collective bargaining agreements, because it can only be for workers who are clearly workers. The third issue you could say is the fact that we're using digital technologies already so much. It can be a little bit difficult to activate this new technology provision in the cooperation committees, because when is something actually new? It's already popping up everywhere. We're already using technology everywhere. So there's a lack of this overall strategy for new technology. And perhaps even if you are discussing, there might be a lack of skills in the cooperation committee to discuss and actually develop principles for a responsible use of AI at the shop level. Very good advancements have been made in the sort of upskilling and reskilling sector. Parallel to this, we have made a pact. There's a pact between the largest white-collar trade union and the finance sector of upskilling and retraining of a number of workers in the use of AI. It's a very big public-private partnership on this. So there is sort of a grassroots, it's coming up that we are trying to retrain and upskill our workers. And this will of course also spill into the work of the cooperation committees. And then our shared pain is that in some of the highly digitalized company, in many small medium enterprises and in unorganized sectors, industries or sectors, there's a low union density. And this means that even these really good results with AI and AM in industrial agreements may not get all out there or to all the workers. So there's this effort to increase the unionization of all workers in all sectors. And perhaps we have this sort of lack of knowledge of what is already available for the use of AI and AM in existing framework. And here GDPR can be a vehicle, but there's still many open questions in that. So good advances, but also still some gaps and challenges from the Danish story. And with that, we say thank you for your time, and we are open for questions and discussions later. Thank you.
Thank you very much, Nathalie. That was super interesting. We're going to go straight to Claire for the French case study, and we will discuss afterwards. Nathalie, Anna, thank you very much. Really nice presentation.
On le met en grand. Slideshow. Okay. It's working. Just do that. Merci. Okay, thank you very much. So I'm going to present the case of France, and I'll try to be quick. Thank you very much for inviting me here. And this report was written in collaboration with Odile Chagny, who's not with us today. So very quickly, I'll present the project we have in France and which has allowed us to organize a first conference on the subject about the French tensions and trends. And then I'll get into the subject. So very quickly, this is the project, AIG for UPEC. And we are trying to create a generative artificial intelligence at our university. And as a result, I lead the research part. And we're asking all these questions about the use of AI at university, but also in companies. And that's why we managed to organize a first table ronde, round table in November, which was an opportunity for us to invite French people and voters and see the extent to which this was a real subject or not. So I'll skip that, sorry. This was just about explaining the project. And yeah, so here we go with the use of AI to start with. So the first thing to say is that the numbers we found were that there is a general increasing use of AI in French firms. What we found was 22% of workers, but my bet is that this is much more than that. But this is what we found in 2024. We're going to find a use of AI in four main sectors. And as a result, a start to worry about AI and to negotiate about AI in these sectors. And so the first one is logistic and administration. And the reason is that these sectors are where there have been legal cases. In fact, there have been issues, and that's the reason why they started to worry about it. Just two examples that I've put here at the bottom. Amazon France Logistique, which was condemned to a 32 million euros fine for watching employees. So they start to realize that, you know, there are limitations, there are regulations, there is a need to find a solution. And this might come from the bottom as well, meaning that it doesn't have to be a law. Similarly, for logistics, we had the first application of our law on the duty of vigilance, due diligence in French, a law from 2017, which had never been applied before, and it happens. And so here we are again, we're starting to realize that, again, these AI, AM questions are big and are going to be an issue in court. Second field, digital platforms, because in France we have specific laws about it. It happened, okay, I won't explain that, but I can if you want. So yeah, this is a specific sector where we are going to find social dialogue. Information communication, bank and insurance manufacturers. This was not meant to be, but this just happened. This is our findings. And in fact, I can show you this table, which has identified where we find collective agreements in the different sectors. And I'll explain later how we found it. But you can see that those main sectors are information, communication, finance, etc. And finally, cultural and creative industries. This is probably because they're aware of it, they're using it, and as a result, they start thinking about how to regulate it. Okay, so then the legal framework. So again, and probably like every other country, we have our specificities. What I'm just going to mention here is that we have our labor code, which has several articles which are relevant. The first one is the first one I've written here. I'm not going to mention it. The point is to say that whenever there is an introduction of new technology, there is an obligation to dialogue, to negotiate on this question, which means that already by law, we know that AI should be a subject that unions cover. And in fact, we have had two cases where it was indicated that it must involve social dialogue. So it's not just an option, it's not a choice. Telework is also relevant, and we have a specific article as well. And so we studied those cases as well, I mean, those agreements as well. Health and safety is relevant because to some extent, and we've already seen it in the previous presentations, health and safety will be a subject which is touched upon by AI. And as a result, we could use this legal basis in order to start social dialogue on the subject. And we'll find this is happening. And for digital platforms, as I said, the specific context, in fact, comes from laws, and I've put them there because they, as a result, they create a legal basis. Same for the public sector, where we also have a law which focuses on the transformation of the public sector, which makes it possible to have social dialogue on this subject. And again, it has happened. So how did we proceed? When it comes to data collection, so as I said, we had this conference in November. We were able to use our network and particularly ODILS with IRES. And then, you know, more my part, the lawyer, I actually had a look on Légifrance, which is the database, and looked for the collective agreements where we could find keywords AI, AM, and digital. And as a result, we found around 400 agreements, sector agreements and companies agreements. And and I read all of them in order to get there. And as a result, I'll conclude that we have 9-10 relevant texts, but I'm going to explain this a little bit more. So first of all, why 400 texts? Because AI appears already quite a bit, already maybe to start with the third one, in the preamble. It appears in the preamble because trade unions are worried about it, and as a result, they mention it. They have to bargain, they have to negotiate every year, and that's why we have a lot of text which must be on Légifrance. And so there is no question there that this a bit reflects a bit the general attitude and the general worries of the trade unions. And so that's the first reason why we find AI, this word AI. This will cover the idea that there is a need to adapt to the transformation of activities, a need to adapt to the disappearance of activities, the disappearance of competencies, and the need to anticipate. We also find it, and that's why I mentioned health and safety before, in our JEP, which is in fact like some document explaining how to anticipate and transform the career of the employees. And so that's why we'll find AI in these different documents. Other reasons why we find AI is because AI will appear as training. And so, in fact, it was mentioned already for Denmark, upscaling, retraining, or just training. We see often that we're going to have, in very specific articles, but I won't explain that here. But we find that AI appears as a way or a need to retrain and a way to create new trainings. AI appears as well, that's the fourth one, as a reason to create a new job. This is something which also has to appear in these conventions, and so that's why we see it quite often there. The point here is to say that we create a new job in order to study AI and its changes, and in order to create an adaptation. And finally, AI appears as, and that's the first one here, as a way to integrate better persons with disabilities. It's not very often, but it has been an idea, and I think it was a great idea. So, having said that, the type of texts we'll find, we have agreements. I've put the French words accord and convention in order to identify that we have several levels, which is specific to France. We have charters, and I wanted to mention that as well. Some chartres du numérique, so digital charters, or charters of the digital, should I say. That's interesting because this is going to actually create extra duties more than rights, and I'll come back to this. Platforms agreements, which I've mentioned already, and telework agreements, which are a little bit different, but we studied them anyway. 10 key agreements, I won't detail all of them, but I just wanted to give you an idea. Why did we consider they were key agreements? Because they really focus on AI and try to go a bit further than just mentioning it as I did. So the point in these different companies was to really try and assess the workers' rights and what protection they could get. So the rights, what do we find in these agreements? So this is a bit of a mix. I haven't chosen one specific one, but that's what I found in the different agreements. So a right to private life and in link with the GDPR, an ability to explain the results, right to appeal, right to information, right to not to be discriminated against. Infobesity, I thought that was funny, I should mention it. I know it's not a word, I mean, it's not a word in French either. In infobesité, it's information about obesity, but somehow in one agreement they felt it was important to say this is really, I think, this is the emergence of starting to think about health and safety issues. So like, spending our lives in front of our computers, is not the most healthy thing to do. And so this is really about, trying to remain fit and, starting to worry about this kind of questions. Right to disconnection. This appeared a lot in telework agreements, but it has not disappeared. And this is a relevant question. Employability, so here we go back to training, which is something I already mentioned. The idea is to help the workers to adapt either to the loss of competencies or to the change of the requirements of the jobs. And diligence on job and tasks. The idea here is to start rethinking the jobs, rethinking the task, and reassessing the need for these tasks and this job at the end of the day. And finally, some rights to solidarity and inclusion. This goes back to non-discrimination, but the point is to keep those, those who are more vulnerable in mind. So what's new there? In fact, what we should say here is that, in fact, not everything is new. And in fact, not so many things are new. And we should really remember and compare to other agreements. And that's what I did with telework, but also with like older agreements. In fact, we have a lot of old rights which are reused and sometimes renewed. But beyond that, we have new rights such as disconnection, data protection. Training shouldn't have been there. And as I mentioned before, charters, I think, is worth mentioning because this also creates new duties. And that's quite interesting because here we find that firms or companies want to indicate to their workers that they should be careful, they should be in charge, they have duties in order not to prejudice their co-workers, in order not to prejudice the company. And so that's also a new development, which I thought was worth mentioning. Lacks and issues to finish, lack of knowledge. I think that's the main thing. In most of the agreements we find, there is still a lack of understanding of what AI actually means and what AI could actually do. We cannot blame the workers for that. I think we're all in the same situation. But the lack of understanding of the dangers and specificities of AI, particularly for each sector, because this is going to be different in each sector, or maybe even in each company, makes it very difficult. So you cannot just copy and paste what has been done in another company. You really need to think about how it changes your own company, and beyond your own company, your own sector, because this will transform the way you work in your company, and as a result, the needs of the workers and the rights the workers might need. The implementation, I think, remains an issue. This is not something which appears in the collective bargaining, but this is, in the collective agreement, but this is something which might appear there because this is the place where the workers can actually have a voice. And so we might see in the future that we're starting to understand how to implement the rights. Like, for instance, when we say transparency, what does it actually mean? Who's actually in charge? At the moment, we have beautiful rights when we have them, which do exist there, but we don't know how they're implemented. I want to mention the fact that, and this was a systemic issue, and it probably, actually, it's just an issue in France, not in all countries probably, but when we're studying collective agreements in France, we're only studying the collective agreements for employees and not for independent workers. There is a little exception for platform workers who are independent workers and have been given this extra right to negotiate with many limitations. I won't go into details because it's already time. But we need to keep this in mind because in France, we're excluding a lot of workers. And finally, I think it would be interesting to have a more global perspective, even if this is a great start, and I thank you for that. And so I'll just conclude by mentioning the capabilities of the workers, because this is really about giving the workers the ability to create their new environment and to create their own protection. And so there was an article in Le Monde, which is a big newspaper, where Thibaut Weber was recommending that we use social dialogue in order to define a collective ethics of use of AI. And I think that's very interesting, because this is what we're starting here. And so that puts us between the static understanding of the evolution and the start of a revolution. Thank you very much.
Thank you very much, Claire. It was incredible, very clear, and you highlighted very French perspective, but I think we can all relate to some of the challenges that already in Belgium and in Denmark were highlighted. So thank you very much. We have a couple of minutes for some burning questions. Online, people can also write in the chat. So far, we received question to have presentation and some compliments, which are always nice. Christina.
Yes, I hope this is working. Yes, first of all, thanks to all the presenters. It was super, super interesting to listen to all of your presentations. I actually started wondering when connecting all those presentations a little bit, because like Wouter started by saying also specifically about Denmark, that you said like maybe because we already have these very general agreements that Natalie then explained also, there is not so much of a need to have specific ones about AM, about AI. And I was wondering a little bit, because when looking at what kind of agreements exist in the general economy, like apart from the platform economy, it seems to be things that we have more or less in all the countries. So like general rules about supervision, general rules about, the fairness in the employment relationship, prohibition of abuse. This is basically what we have everywhere. But where it gets really interesting is then when you have a specific software, which kind of functions do we allow, which ones do we not allow? How do we inform employees? How does this work in order to also not create information overload so that nobody understands it any longer, as opposed to not communicating at all? So these are very specific questions. So my idea was, in a way, might it also be a sort of an issue that at sectoral level, when you're bargaining, it's kind of really difficult to address these things, so that in many countries it might really be something that, because also for the French case, basically the best agreements were all company agreements, so that it is really something that in many countries is addressed more at the company level and can be addressed better at the company level. So that's kind of a question to all of you. Somebody wants to react to that. Thank you.
Yeah, mine is a question linked to the one of Christina, and it concerns the Danish case. So I would like to know, in case of the ILF agreement, were they triggered mainly by the company run, Natalie, you said by a smart and successful Danish guy with very well aware of the Danish model. So it was mainly the company that demanded this kind of a company collective agreement, or were the trade union that demand for a regulation of the artificial intelligence?
Maybe Anna, Natalie, and then we go break.
Yeah, we can reply to these questions and then we have the coffee break. Thank you.
Sorry.
Okay, then as there was a related question, Antonio, and then the Danish team.
And then we'll bother Claire in the break, and then
Yeah, also some online we received, but one is a specific question for Claire, so perhaps we can interact with the online.
No, very briefly, thank you very much for the three presentations. They were very clear. And I was wondering if the underlying legal framework is also a success factor, because this was an element that was highlighted in the French and in the Danish case in particular. We're referring to the Danish legal framework. You stress the importance of a general provision on the duty to justify the exercise of managerial prerogatives prerogative by relying on just cause, right? So perhaps this is also a critical aspect to take into account. I was wondering what the role of trade unions has been in mobilizing these overarching legal principle according to which employers, bosses, supervisors who are willing to exercise power need to some extent to justify such a power.
Before giving the word, perhaps we should give justice to those who asked a question online, specifically the general question. Then it's from Dan Maggi, who is asking, basically the point is transparency is obviously a key concept. It was present in some of the agreement you discussed. However, is there not a risk that becomes a box ticking exercise? Is there more that you found? That was the question. We cannot ask all of them. Natalie, Anna, please, the floor is yours.
Sure. Thank you for the questions. And Anna just joined me here. I'm going to answer the question about the existing legal framework and the requirement for just cause. Because this is such a well-known principle in any Danish workplace that any managerial decision can be challenged, not only dismissals, but actually also in ongoing work relationships, you can challenge a managerial decisions, whether it is sort of beyond the managerial powers of the employer, whether it reaches into the privacy of the employees, or it sort of asks the employees to do something that is too dangerous and so on. You can always challenge that. And of course, I think that plays a big role, that you have that in the background already. And I kind of agree a little bit that if there's no burning platform, right, we don't necessarily need to run in and do a lot of stuff on AI and AM. And I think that can be the approach perhaps from the employer side, that we already have this. So in case anybody has problems, we can just, bring it on. Whereas I think at shop level, the developments that we have seen are quite significant and kind of shows that there are some special issues here that we need to address. There are some issues that we need to clarify, not only for the workers' rights, but actually also for the employers to feel free to engage with the use of AI and AM in responsible matters, in ways that have upfront been deemed responsible, right? So that clarify for everybody that this is perfectly fine. And I think that connects to the first question on whether this goes on mostly at shop level, and the answer is yes. It does, because when you negotiate at shop level, it allows you to adjust to this type of company and this type of use of AI, and it's also perhaps a little bit easier to agree with one company and make something that's specific for that company. And if that's a success, it gives a model for the entire sector. That's what we saw with, we started with the cleaners agreement, but we've actually have the sector agreement on food delivery that kind of, I would say that's been inspired by the fact that there was an agreement with the digital platform already from 2018. And then the sector agreement in the food delivery sector was able to be concluded because, there was a model already. So it has a spillover effect on other from the company level to the sector level. At least we've seen that once. Anna? We have the question on who initiated this bargaining process.
Yeah, so thank you very much for these excellent questions. I think raises some of the most important points. Let me first comment on the level of the regulation, because I think that was perhaps one of the comments that I think will also be relevant for all the chapters in this great collaboration. I think there's a reason why we see most development at the shop floor level, and that's because the speed of change of AI and algorithmic management is so different to a situation where we see a management deciding to buy a robot and introduce that into a company, and then they inform and hear workers' representatives in a works council. That's a very different situation compared to now with AI and algorithmic management, which is changing almost on a daily basis or maybe even more often, and is so different from company to company and different sectors. So I think that's one of the drivers why we see a lot of activity at the shop floor level and not so much at sector level. Also, I think because maybe it's more difficult to make rules on the content of this type of technology than robotic automation, and maybe we'll see more rules relating to the process on how to deal with this, like for instance, ethics boards and something like that we've seen in other companies. So I think definitely the company level is going to play a major role in this, not just on collective agreements, but also in works councils and variations over that topic. Then specifically on the Hilfa agreement and the question on that, who initiated that and so on, it's very interesting because initially in 2018, it was very much the company that initiated these negotiations because they wanted orderly conditions on the platform, and they wanted to interact more easily with the tax authorities and other institutions of Danish society. However, the renegotiation of the agreement in 24 was very much also driven by the union, and the union wishes to have regulation of AI and algorithmic management. And Natalie explained very much in detail what that regulation has in content. But I've been interviewing Hilfa Management continuously since 2017, and recently I've done a few interviews also displaying a very interesting interpretation of the word algorithmic management. So how they interpret that is that we have rules on algorithmic management in the agreement. However, there's also a type of analog algorithmic management. So Hilfa Management interpret this as you also need physical management, human intervention to make this work. So what they do is that they continuously follow up on various outlier figures in the algorithm and contacting workers manually, calling them on the phone to try to interpret any outlier the algorithm has, because often it's not an outlier, it's just a fault, it's a wrong thing of the algorithm. So they're kind of correcting on a daily basis over the phone any strange figures that comes up with the algorithm. So that says that's the management part of things. That's the old traditional management combined with the algorithm. And I think that's pretty interesting because this is a very advanced case that they need to have this kind of analog management practice to have orderly conditions on algorithmic management, because often wrong figures in algorithms are not workers that have done anything wrong, but it's just the algorithm hallucinating or things like that. So also in practice, this is a very interesting case of algorithmic management, not just from the legal text. So thank you very much for that question.
Thank you so much. Keeping time in sight, even though we're losing track of it already, I would ask Claire now to speak for a couple of minutes to respond to some of the questions. And then we're just gonna, or if just speak, yeah, it might be interesting for other people as well. And then we'll just move the break 50 minutes ahead. So we'll just kick the can down the road. Thank you very much, and Claire, out to you. And also just for the people online, any questions we don't answer here, I invite the speakers also to respond to questions online if they want. Any questions that are not answered, we'll pick up in the roundtable afterwards.
Thank you very much. About the first question about capabilities and knowledge of workers about AI and AM, I think the methods proposed in the question are very interesting. I was particularly thinking of training sessions. And in fact, in France, we have OPCOs, so these like our training institutions, which have started to get into the subject. And that's very interesting because there is really a choice from the states, really. I mean, it's at regional level, but it comes from a state decision. And so all these organisms, all these institutions have now decided to take it upon them to train companies and in general and employees on how to use AI. And I think that's that's a very interesting way to start changing the methods and practices. And that's also a first way to start thinking about how to protect the workers. And so that's what I was thinking about. Regarding the second question, sorry. I'm sorry, what are CLAs? Thank you, collective agreement. Yes, we do have collective agreements about salary levels. That is particularly true in the platform sector. And in fact, when I didn't insist on that, but I thank you for giving me this opportunity. In the platform agreements, we only have 4 of them. 2 of them are about salaries. And it's very interesting to see that, in fact, algorithmic management does not appear so much. So we have kind of traditional agreements about what the salary should be per hour, etc. But in fact, the fact that it's algorithmic does not come into the question when I think it should, because it has quite an impact on how the salary is calculated and what incentives are. And in fact, that would be maybe an open door to get into how to understand the black box and the incentives and the way salaries vary depending on the time you're doing the delivery, or because these platform agreements are specifically for deliveries and taxi drivers pretty much. And so yeah, that's it. Thank you very much.
Perfect. Thank you for all those who ask questions, and those who reply, and those who listen. And now we take a quick break. For those who, I would say it was 10 minutes. So see you in a bit. Thank you very much for still being here. So now is the moment to continue with the country analysis. We have Nele and Christina. Yeah, Nele is online, but Christina is not in the room in the moment. So I should have waited before starting, probably.
Okay.
Let's wait a couple of minutes. But I think it's better if Christina is in the room. Sorry, Nele.
No problem. Maybe we can just talk about the technical issues. Should I share my slides, or will you share them and I tell you when to click to the next slide?
Angelique, can you reply to this? Yeah.
No, maybe she shares them.
I think normally you will share the
Yeah,
slide.
if you can share the slides, then that's fine. But then when Christina takes over, she also needs the slide in front of her, right?
I guess so, yeah.
Yeah, okay. So then when you are, because then maybe it's best that I share from here and you tell us when to move on, because then we don't have stop sharing, reshare.
Yes, that's what I thought.
I will, yes, okay, I will share from here, so.
Perfect.
And now Christina Hissel is joining. And we can start with the German case. Thank you very much. The floor is yours. 15 minutes. Thank you.
Okay, so I'll start. Hello from Germany, and thank you very much for this interesting conference. As you have already said, Christina Hiesler and I will now present the findings on collective agreements and works agreements on AI and algorithmic management in Germany. Now would be the time to click to the next slide, please. Thank you. First, a very few words about the proliferation and the use of AI and algorithmic management in German enterprises. As we've already heard in the beginning, Germany is not necessarily at the forefront of digitalization. According to the German Federal Statistical Office, 20% of German enterprises were using AI in 2024. But the use of AI varies considerably with company size. According to this data, 48% of enterprises with more than 250 employees used AI, but only 17% of those with between 10 and 49 employees. And it also varies between sectors. For example, AI use is higher in the IT sector, as we've already heard, in financial and insurance services, and also in manufacturing. And also AI can be put to various uses. According to this data by the German Federal Statistical Office, it was most often used for text mining by 48% of the responding enterprises, for language recognition 47%, and language generation 34%. Of course, it can already also be used to manage employees. For this, I can quote a survey from the OECD from 2023 on 7 countries, including Germany, in manufacturing and finance, that found that 6 to 7% of employees reported that they are managed by AI. Then there's another survey not only asking for AI managing employees, but applying a very broad understanding of algorithmic management. This time among managers across 6 countries, again, including Germany, from the OECD in 2025. And this survey finds an adoption rate of algorithmic management at 79% among European companies. But as I've said, this definition of algorithmic management is much broader, including, for example, the use of software to collect data on employees' entry and exit times at work without further processing this algorithmically. So summing up this very short overview, I think we can say that proliferation of AM and IA in Germany is perhaps not as widespread as discussions about it might suggest. It is also spread unevenly across sectors and also according to company size. Of course, it's also dependent on the definition different surveys apply, but it certainly does play a role in the German labor market. And summing up very briefly, I think we can say that the effects of AI and AM on work that are most widely discussed in Germany are employment effects, questions of changing tasks and qualification, and also the issue of control and autonomy at work. Now the next slide, please. Thank you. Our aim was now to find out if and how these issues are addressed in collective agreements in Germany. To find collective agreements on AI and AM, we searched a publicly available database of collective agreements by the state of Hamburg, which also encompasses Germany-wide agreements, but not all of them, because unfortunately there is no publicly available database for all collective agreements in Germany. So we had to use this Hamburg database instead. And we also sent email inquiries to the 3 biggest German trade unions. And because of the specific German system of employment relations, where we have works councils at establishment level that have co-determination rights on a range of issues, we also extended our search to works agreements. That is, agreements not between unions and management, but between works councils and management. Christina will say a few more words on that later. And for the level of the works agreements, we conducted an internet search and a literature review. Now the next slide again, please. I will present very briefly the results of our search for collective agreements. So that is agreements between trade unions on the one side and employers associations or single employers on the other side. And Christina will then present the results on works agreements. Overall, by searching for keywords, we found 30 collective agreements that address digitalization a bit more broadly and AI or AM in particular. To our knowledge, there's only one collective agreement in Germany at this moment dealing specifically and in some detail with AI. It was concluded very recently, and in fact, after we had finished our draft report for this project, it's in force since March 2025, and it was concluded in the film industry by Verdi. And it's specifically on generative AI, regulating questions of consent and remuneration for the use of digital replica of actors, as I've said, in the film industry. We found 2 more collective agreements that mention AI, but only as one aspect in a more encompassing collective agreement. And we found none that mention algorithmic management. But there are, however, some collective agreements on digitalization in general, and also on IT-enabled remote working. And these collective agreements on remote working, for example, they may contain regulations on data protection. Some also regulate a right to disconnect for employees. And the collective agreements that deal with digitalization more broadly, for example, contain regulations on employment security, on qualification and reskilling, and some also establish new bodies or new processes that give employee representatives a say in these digitalization processes. And moreover, I think it's important to note that issues as reskilling or also employment security are also regulated in Germany in collective agreements that do not specifically mention AI or digitalization, but they might nevertheless be applicable in shaping developments with regard to the introduction of these new technologies. So to sum up this situation of collective agreements, very few collective agreements so far in Germany specifically mention AI. Some mention digitalization more broadly, and regulations in other collective agreements that are also already in existence for a longer time could also be helpful to manage effects of AI use, such as employment effects, for example, or changing qualification requirements. And with this, I hand over to the level of works agreements, which is a bit more interesting.
Okay, is this on or do I have to push? No, it's on, I think. It's on. Okay, great. Yes, thanks a lot, Nele. Yes, before I go specifically to the company level, which, as Nele already explained, is a lot more specific than the microphone. Okay, now? Better? Yes, no? Okay, great. Yeah, so before I go into the works agreement specifically, let me say a few words about the legal particularities, because I think it explains a lot. It's also, in a way, why I asked the question before, because for Germany, I think it's kind of logical that the main thing will happen at company level. Why? Because, as Nele already explained, there's basically this dual system. On the one hand, you do have a kind of relatively standard legal framework for agreements with unions. I think the only particularities that we have in Germany are rather making the system a little bit weaker than in other countries, specifically because it's very difficult to sectorally extend collective agreements. So when we're talking about sectoral agreements in Germany, it's not the same as in Belgium or France, as you had it before. It's not covering the whole sector. It basically covers only the employers that are a member of the employers associations that concluded. And even we don't have an erga omnes effect, which is really kind of very exceptional thing in Europe. That means that an employer that is bound by a collective agreement even does not have to apply it to all of its workforce. It only has to apply it to union members. Like in practice, most are at least claiming to apply it to all the workers, but it's not necessarily a legal requirement. So I would say here the legal system is actually a little bit weaker, I would say, than in other countries. What we also see certainly at the sectoral level is a very steep decline in coverage, which is also steeper than in many other countries, because basically all of Europe we have decline, but in Germany it's a little bit steeper here. And then comes the specific level of the works councils, which is the entire opposite of this, where the German works councils' rights are, of course, stronger than more or less everywhere in the world, except for Austria, which has a very similar system. So you have a right to co-determination of lots and lots of areas of labor law, very many areas of working conditions. Specifically for AI, the important ones I would say are the introduction of any technical equipment that could be used in order to supervise employee behavior or performance, which applies to basically all forms of algorithmic management or AI, meaning that it basically all has to be co-determined. Also, if you're introducing any form of general rules on recruitment or categorization of workers or on dismissal, that also has to be co-determined. And even individual decisions on workers, individual personnel matters are co-determined. What does co-determined mean? Co-determined means that if you don't have an agreement with your works council, if it exists, that's the main point here, basically. If you don't have an agreement with your works councils, you can't introduce the measure as a management. You would have to go to an arbitration body in order to impose your opinion without the works council really agreeing. So that's a relatively strict precondition, which also has an impact on how these negotiations are taking place. Because in the end, it's the employers that are initiating the negotiations usually, because as soon as they want to introduce something, they first have to go to the works council, say, are you fine with this, or do we need to negotiate about this? There's also been a very interesting reform in 2021, which specifically addresses AI, saying that if there are AI-made decisions, they obviously also have to be co-determined. So if there's AI deciding about dismissals or recruitment and so on, of course, they also have to be co-determined. It also says the Works Council always has a right to an expert. If AI is involved, there's a non-rebuttable presumption on that. And the last thing I would mention is that what is also very exceptional, I think, in Europe is that you have Works Council organization at group level. So it's not only establishment and companies, also group level. So as soon as you have a kind of hierarchical structure, there's always a right for the workers to have a Works Council at group level, which is usually a very, I would say, a body that has a lot more possibilities and a lot more expertise than you would have at the lower levels. Yes, and now I would come specifically to those works agreements that are really this particularity, which I would say. The main characteristics that I would see for the situation here, so we basically, as Nele mentioned already before, we basically just took whatever we found for the Works Council agreement, because there's no database whatsoever. There's also no duty to publish them. And usually you would also need the agreement, basically, of the workers and the employer side, of course, to publish them. This is usually not done. So we had, for a few agreements, really had the whole text. And for a few other agreements, we had at least detailed interviews about the context or a detailed description that was put out by the company. Otherwise, you just don't have access. So we really have no idea how common they are. We have the feeling that it's not covering the major part of the workforce, but we found a few that are quite interesting. We basically based this assessment on 10 agreements for which we had enough information to really say something about their contents. And these are now mostly group level agreements. I already told you group level being very important here. And it's usually also international groups, which also means that the German agreements potentially also have an impact on other countries. So if the group also has subsidiaries in other countries, the agreement that is made on group level about how to introduce certain software, what are the information rights, could also impact other subsidiaries in other countries. As I already said, very often they're initiated by the management, which is also a particularity. As for the contents, I think I would identify 6 areas that are very interesting. So the content of these agreements that we found are, I would say, really very interesting, because they are very detailed in a number of respects. They all specifically refer to AI. They all specifically referred also to algorithmic management. So they are, compared to those or to those sectoral agreements where you hardly find a mention of AI, they are extremely detailed. The first thing they usually contain is commitments, which of course as such are relatively vague, but they can be very, very useful for interpreting them, like commitments to fairness, to transparency, to data safety, health and safety, non-discrimination, and so on. So there's a lot of this commitment by the company to use AI and AM in a fair way. There is very detailed transparency requirements very often. So the idea of, if you introduce any kind of software, you first have to establish a profile for this kind of software in order to give workers representatives, and also the workers that interact with the kind of system, the AI or whatever it is, a good idea of what is the risk that this system can pose to me, how can I interact with that system, and what might it mean for my working conditions. So to really have, sometimes they develop a profile, sometimes it's a kind of risk-based categorization going from unacceptable risk to like negligible risk, which also helps workers to focus on the ones that might really pose a risk, because some of those companies are really tech companies that are introducing software all the time, which also makes it extremely difficult for the Works Council that has to go into negotiations on all of them to really know what to focus on, what is really a danger for employees. So that's also the transparency requirement. Yes, the next point, procedures. So many of those agreements also say very specifically what the company has to do in case it wants to introduce any kind of software that contains AI. What kind of information does it have to give, within which timeframes, who has to be informed, even which part of the Works Council, because the Group Works Council usually has an IT department, but the IT department is already overwhelmed by too much to do. So there might be other areas that should be contacted first, ethics department and so on. Yes, also about whistleblowing, for example. So if workers are interacting with the software and they have concerns, where can they turn to? Can they receive a decision? How can they report their concerns through safe ways? Red lines, I would say, are also very interesting, because the agreements that we looked at, and that's what surprised me to a certain degree, is that they usually really prohibited any automated form of decision-making, and even sometimes automated form of suggestions for specific decision-making about employees. So that's what basically surprised us, that the companies would really commit to not using any forms of those, even though some of them are really tech companies where I think maybe they would be skeptical, but most of them really contain that. Training, so that's something that we, I think, see in all of the countries of the specific countries, that very often the idea is that AI could, of course, be used to replace us. So in the end, there should be a proactive training requirement whenever the employer has the feeling that this software could in the long term replace certain employees or make skills obsolete. We should, of course, proactively address that by retraining employees. And then social dialogue social dialogue related concerns, like how should information of the Works Council really work? How should co-determination work? Sometimes also a cooperation with a data protection officer, which of course also exists in most of those companies. And then very often there are parallel structures in order to include both forms of consultation. Yes, and that's basically already where we stop. So what can we say about the German case? I would say basically very innovative approaches, very interesting things that we find in those few agreements. So it's really based on 10 agreements, the analysis that I just presented. Also interested in that they are embedded in existing agreements. So many of the companies have basically a general agreement on IT, for example, and then you add rights based on AI. So it's also kind of a generic process. Yes, it's also very, so the legal system, I think, also gives an advantage to, I think, things that are not necessarily formal agreements, because as soon as an employer that is already informally kind of establishing a system, for example, categorizing AI in risk categories, cannot basically change the system without consulting the Works Council before. So basically you also have this quasi-mandatory nature of the practices that have developed, because as soon as you want to change them, you have to go through the Works Council again. And then finally, I would say the main issues are really that it's still a very, very small minority, according to our feeling at least, that is covered by any certain form of agreement, either at company level or also at the sectoral level. So that is really, I think, one of the main challenges that we have. And yes, I will not go into the details on the legal issues that we have, but I think there's still a lot of hurdles to overcome in order to mainstream the innovative approaches that we already have. Thank you.
Thank you very much, Nele and Cristina, for this presentation. Very clear. Yeah, we give the word to the Italian expert now on the Italian case, Silvia Borelli and Maria Grazia Lamannis. And we are collecting some questions. If the speakers want, I can already reply in the chat. There are some questions. Otherwise, we will pick them up after.
Yeah, so good morning. And first of all, it was a pleasure to work with Maria Grazia Lamannis, that is really perfect as a partner, because she is super organized. And so it was a pleasure to work with her. Now I'm not able to go on. This is the reason why I need someone to work with me. So the methodology. For us, this kind of report was very difficult to write. Why? Because as in Germany, we don't have a national database for company collective agreements. So we have databases that are organized by trade unions, by some university, for example, Bergamo and Brescia, they have databases, but we can't really use these databases, meaning that if we want to research on company collective agreement, we have to read the full text. It's not possible to do researches on keyword. We have a database for national collective agreement, but in this case as well, we can't do a research on single word. So in this case as well, we need to read the full text of the national collective agreement. A problem for us is that in Italy, we have, according to the last data that we could consult, we have 1,089 national collective agreements. They are too many, let's say. Why do we have so many national collective agreements? Because as in Germany and in Denmark, in our country, the collective agreement, they don't have erga omnes effect. So they apply only to employers that are part of the employer association that has signed the collective agreement. And it means that we have several national collective agreements for the same sector and beside the sector overlap, because each collective agreement, each national collective agreement can define the sector to which it applies. Second problem, company level collective agreement can derogate, of course, derogate for the words, national collective agreement and the law. This was a legal change that was introduced in 2011 because the European economic governance, we were forced to increase, to decentralize our collective bargaining system. And because of this push, we decided that the company collective agreement can derogate the law and the national collective agreement. And they can do this, they can derogate in case of introduction of the new technology. So, of course, for us, this is really a problem now. A problem because differently that in the Danish case, for us, the industrial relations system, the general principle of the industrial relations system, they are not respected by the company level agreement. So these are the main law that deal with artificial intelligence and algorithmic management. I don't enter into the detail because we don't have time. The first law is a very, very old law. That the Italian worker statute was approved in 1970, but it's still the most beautiful law for workers, but after the Constitution, of course. So it's a very well written law, very, very important. And already at the time, it said if the employer wanted to introduce devices that allow to control workers' activity, they have to negotiate. Second, in 2022, it was introduced the obligation for the employer to inform, just inform, not to consult, to inform worker representative in case of use of automated decision-making and monitoring system. And this obligation concerns not only the worker, but also the collaborators. Third important law concerns telework that we call smart worker. So our research concerns mainly 4 sectors. no, sorry, 5 sectors. Yes, 5 sectors. The first 2 are education and research and healthcare. Here, I will be very, very quick on this slide. Why? Because here we have 2 sectors that basically they don't consider that in this sector, the collective agreement, they don't consider artificial intelligence and algorithmic management. For 2 main reasons. First of all, public sector, where the trade unions are stronger, the collective agreement, both for education and health and care, they haven't been renewed yet because of public budget constraint. So these are old national collective agreement, and because they are old, they don't deal with artificial intelligence and algorithmic management. In the private sector, the problem is that we have very, very weak trade union in this sector, and the national collective agreements are very, very fragmented. The case of logistics is a bit better. Here as well, we have a huge collective contractual dumping at national level, meaning that we have too many national collective agreements, 82 collective agreements, national collective agreements for the logistics sector. They are signed in order to lower the labor cost. However, the main collective agreement for the sector, meaning the collective was renewed in December 2024, and because of the recent renewal, the artificial intelligence and algorithmic management system are considered. In particular, we have a duty to involve a worker representative in any organizational change that entail the introduction of new technology. And the qualification system has been updated in order to introduce new professional figures. And this is very important because it means that it affects salary and worker condition. And it's not written in this slide, but there is also a regulation of the right to disconnect for all the workers. And now I leave the floor to Maria Grazia.
Hello, everybody, and thank you, Silvia, also for managing the slide. So we move now to finance. That was a sector with huge investments and research related to the use of AI. Nevertheless, specific regulation in collective agreements of the sector is absent. At the national level, we have 4 interesting collective agreements because 2 of them include the joint declaration on the impact of digitalization on employment and the joint declaration on the use of artificial intelligence in the sector by the European social partners. This means that those declarations are part of the agreement and then are binding for the signing parties. 3 agreements at the national level establish a joint body to monitor and study the implementation of AI and IM. And these happen also at the company level in the agreement signed by Groupama, that is also a bank. At the national level, it was also interesting to find out that the agreement signed by ANIA not only provide for training for workers affected by digital innovation, but also, like in the logistics sector, allows the update of professional profiles, including those arising from the implementation of these technological innovation. Finally, the last focus on the finance is related to the joint statement mentioned by Silvia Renone at the beginning, signed by UniCredit and its European Works Council. This statement concerns remote working, but parties agreed to monitor technological innovation, especially related to AI and algorithms, also by updating the joint statement. The other sector we analyzed was the metalworking industry. Here as well, we can move to, okay. We have 55 national collective agreements, but none of the national collective agreements concluded by the most representative trade unions that in Italy are CGL, CISL and WIL covers the use of AI and IM. Luckily, the situation is expected to change because the federations of those three trade unions proposed to include specific regulation of AI in the renewal of the main national collective agreement for the sector signed with Confindustria, Federmeccanica and Assistal, as you can see, and also in the renewal of the national collective agreement for the gold, silver and jewelry industry. Here is also interesting to know that we have a specific national collective agreement for cooperatives operating in the metalworking industry, but this agreement is still on the Industry 4.0. At the company level, here again, we have no specific regulation at least available for us, but it is worth mentioning this Electrolux agreement because the introduction of new digital communication tool is subject to a joint analysis with worker representatives. And here again, that is something recurrent, as I will say. We have a joint technical committee specific whose specific competence is to analyze and examine projects related to digitalization. Then we have a final look to some other sectors different from the 5 we targeted from the beginning. And here we have a couple of examples that looked more interesting for us. The first one, like happened in Germany recently, concerned the film and audiovisual industry. Already in 2023, two national collective agreements concerning the audiovisual industry prohibited any extraction of the performance, any sampling and reproduction of the performance, voices or images of people to develop or train artificial intelligence and algorithms. So this is the most explicit regulation we have in collective agreements concerning the use of data to train artificial intelligence. We have some interesting provisions also in the chemical industry because Sanofi joined with CGL, CISL and WIL a digital and AI pact. We have also 2 interesting protocols and agreements in the construction center. I would like just to mention, but I can't go deeper, the protocol concerning the Technopole Data Valley Hub of Bologna. And very recently, also the most important national collective agreement for the energy industry established a joint observatory on the issue. So to conclude, how is the situation in Italy? We have both positives and negative trends. Starting from the good news, trade unions and workers are increasingly benefiting the right of information and consultation to be involved in decision-making processes concerning the implementation of new technology. So here, as Silvia said, we benefit from a legal framework that started with the workers' statute. Then there is a tendency to set up bodies or observatories participated by both employers and workers' representatives. That means to us that social partners are studying artificial intelligence and algorithmic management. They are not already into detailed regulation, but they are starting to study to understand well the problem and the issue. It's important to highlight the modification of personal classification system because, as mentioned by Silvia, this affects the overall economic and normative status of workers. And of course, we have also many rules on the right to disconnect, privacy issues, and so on. Moving to the negative trends, indeed, they mirror all the weaknesses of the Italian industrial relation system. So this is why algorithmic management and artificial intelligence are still under-regulated by collective agreements. More in particular, the main weaknesses are this tendency to decentralization of the regulation that is prompted by the legislature, especially concerning the case of remote working and smart working. There is an opacity in accepting the company level bargaining, and at the same time a huge delay in the renewal of the national collective agreement. And then the very final point is the risk that the introduction of new technology will prompt further the tendency to decentralization. So for us, the very final question is a big one: how to correct these historical critical issues and weaknesses of our system, also to prevent the undermining of the positive impact that AI and AM could have in the long run for both workers and employers. So it's all for now, and thank you.
Thank you very much. Thank you very much, Maria Grazia. So we cheer up talking about the Dutch case.
As we always do.
Yeah. Yeah. And give the word to Elisabeth and Juliana Landono. This is a project which involves also Maike Auberzeil, who cannot be present here today. But nevertheless, she's one of the main contributors as well of this research.
Introducing Maike. I hope she's able to join online and can also pitch in for the Q&A today. So this might be, I don't know if this is a cheering up story, but I'll leave that up to you to decide. We are going through our main results pretty quickly, I think. And I'm very happy that we are not the first one to present, because I can already refer back to some of the presentations that have been presented already. And we saw the Netherlands as one of the also front runners in terms of digitalization. I saw the Netherlands next to Denmark and Finland, I think, in terms of use of digital means. And I think also the use of AI is definitely increasing in the Netherlands, especially in the big companies, 50 plus employees. And we see specifically a lot of use in the information and communication industries, but also in specialized business and financial services, for example. Maybe very shortly on the Netherlands in terms of industrial relations systems, we have a high collective bargaining coverage. The estimations differ, but it's still 70%, maybe a bit more. Basically, the main level of collective bargaining is industry level, but we also do have a lot of company agreements that will also appeared in our research. And in the Netherlands, we do have legal extension of collective agreements, hence the high coverage. Trade union density, however, is rather low, with maybe 15%. So that's just to give you some idea of where we are in the Netherlands. So what did we do in terms of data? Where did we get our input for this chapter? We managed to do a query research in the FNV database. The FNV is the largest trade union in the Netherlands. And this resulted in almost 400 collective agreements, but most of the agreements were dealing with issues around remote work or the right to disconnect. And there were far fewer collective agreements that actually said something about digital or technological issues, and even fewer on AI specifically. I think most of the collective agreements that specifically mentioned something about AI or algorithmic management came from the interviews that we conducted with trade unionists and an employer organization. And these were really very new. So also concluded after our query research. So they were not included in the database yet. And we also did a workshop where we brought together scholars and social partners to discuss social dialogue and collective bargaining and the impact of artificial intelligence on that. So straight to the findings. Collective bargaining, as we concluded in the chapter, but maybe we're wrong, so please tell us. We think it's still at its infancy in the Netherlands, but it's developing rapidly, and we specifically see as front runners in that the creative sector and banking and insurance, so more the finance sector, where we had sectoral collective agreements specifically addressing AI issues. We'll save the best for last because Juliana will explain what was actually included in those collective agreements. But what we did in our study is also look at sectors where you would expect maybe something concrete on AI, such as sectors as logistics, where we know that a lot of algorithmic management tools are used, to explore why this didn't result in agreements, in collective agreements. And what we also found in the Netherlands is that there are also other collective bargaining instruments that are used to regulate aspects of AI. And we particularly want to point out a couple of them, and I'll explain that in a moment. So first, I've heard Amazon in a couple of countries popping up. Amazon also discovered the Netherlands 5 years ago. And I want to point out this example here, also to show a little bit of the industrial relations context where trade unions need to bargain with very powerful employers. So here you see a still from a short video clip that the Dutch trade union recorded once Amazon landed in the Netherlands, explaining them something about the Dutch system of collective bargaining and how we are doing things in the Netherlands. Very nice, very compelling, I think, but Amazon didn't think so. So they didn't even manage to get a coffee with Amazon after 5 years. So that's how bargaining sometimes goes in these kind of industries, where you face very powerful employers, very international employers, compared with trade unions who have really have a difficult situation in terms of union density in those sectors. So besides the collective agreements, we also saw a rediscovery of some instruments that were out there in the Netherlands but haven't been used that much. And then we are specifically talking about the Occupational Health and Safety Catalog, called the Arbo-catalogus in the Netherlands, where trade unions and social partners can make agreements on working environment circumstances. So this is next to a collective bargaining agreement. And this is usually at the sectoral or branch level, where they can make these agreements or provisions. And we also found, was also a bit of a lucky shot, that certain technology agreements that actually have originated from the 80s, when you also had a lot of automation happening. And we saw some collective agreements where these technology agreements were still an addendum to the collective agreement. And they actually were literally from the 80s. So this is one collective agreement from 2021, where this agreement from 1987 was still included. So that's more in general about technology, but it can still provide social partners a way to approach the issue of AI and algorithmic management. Another one that's similar to Denmark and Germany is the role of works councils in the Netherlands. According to the Dutch Works Council Act, Works Council have the right to consultation when it comes to the implementation of new technology. And they also have the right to consent in terms of when it comes to personnel tracking systems. So they have formally quite an established right, and that might also explain that we see less in collective bargaining agreements because we also have these other routes in the Netherlands. And then finally, I want to point out to the sectoral social funds, which is also a way that this is paid for by social partners in different sectors. And that's also been used, for example, in the public sector. This is still from a theater play on AI for public servants. Yeah, sounds fascinating. Must say it was completely sold out, so we weren't able to attend it. But that's also a way to for social partners to work on providing provisions for like AI skills or AI awareness among workers. So with that, I'll leave it up to Juliana.
Thank you, Lisa. So as Lisa mentioned, there were several collective institutionalized instruments, but now we will dive a bit into how the collective agreements were regulating the issue. So here we classified the agreements according to the material scope or the topic that they were regulating. So as Lisa already mentioned, we had some peripheral issues like remote work and the right to disconnect, which were widely spread. For example, 1/3 of collective agreements in the Netherlands approximately regulate remote work. So this is quite frequent. And although the right to disconnect was less frequent, it was still not an unusual clause. Then we had some clauses that related and regulated technological innovation, automation or robotization, although not specifically referring to AI and AM. So we had 10 clauses granting workers rights to training and education, and 7 clauses granting workers representatives rights to information and consultation in response to technological changes. And finally, we had those clauses that were the most connected with the query at hand. That was those clauses that granted workers' rights in response to comparable digital management practices that surveil or supervise or control workers that could be seen as the forerunners of AI and AM. And those clauses that granted workers' rights directly related with AI and AM, which were 5 and 4. So let's see a bit how they regulated it. So the forerunners or clauses that regulated comparable digital management practices, here we have 2 examples. One of them in the collective agreement of Albert Heijn Logistics. So they have within their company a minute standard that is a sort of planning tool that instructs the work effort, but also is used to monitor work performance, employees' performance. So the collective agreement establishes a clear limitation to this minute standard by saying it can be an element to assess workers' performance, but it can never be the only element in the assessment. It needs to be together with other elements. And it also states that, interesting perhaps in the personal scope, that it also applies to temporary workers and not just to the direct employees. Then we have the call center sector, which also had a very interesting clause on quality monitoring. And this clause distinguishes quality monitoring from voice logging. And quality monitoring refers to how the employer, by checking the calls, can coach, develop guidance, and improve the quality of the service, which is different from voice logging, that is when the client requests the call to be recorded. And a very important element of this clause is that it highlights the role of works councils and staff representation bodies within quality monitoring, as they have a right to consent in any agreement regarding quality monitoring. And here we observe a bit more the specific clauses on AI, which one of them was in the dance and theater sector. As Lisa already highlighted, the creative sector was one of the important actors in AI and AM in the Netherlands. And one of the elements that they really strive to regulate was intellectual property. And this clause exhibits it. Because although it highlights that AI might provide important opportunities, it also its use can symbolize or bring some risks, and it specifically states that the employer will not cooperate in allowing the recordings to be used for training AI, And not only will it not cooperate, but it says it will use all the means at its disposal to prevent the recorded material from being used to train AI. So here it's very specifically regulating this issue. And then on the collective bargaining result in banking, we can see also an important element that, first of all, they mentioned that they will put AI in the agenda for the coming period, but also it makes an important stance with regards to training, because it states that AI skills development should be considered necessary for the job, which pursuant to the collective agreement means that the training on AI needs to be done during working time and at the cost of the employer. So it has very tangible effects. And finally, our agreement on collective bargaining in the insurance company was also very interesting. First of all, it provides a definition of AI, which is interesting. From what we could see in the Netherlands, it's the only agreement that does this. And it also highlights the importance that employers must inform employees about the use and impact that AI can have at work. And finally, as already mentioned by Lisa, with the health and safety catalog, it's that this elements that AI impacts. So these are just some examples that aim to highlight what already Elisa pointed out. Although collective bargaining in the Netherlands in AI and AM is still a developing field, it is developing quite quickly, and it's doing it not only through collective bargaining, but it's also rediscovering other collective bargaining instruments or collective institutionalized instruments, such as the health and safety catalogs, and making use of the older technology agreements, as well as sectoral social funds and work councils, right? So it's really not only collective bargaining, but beyond this. So this is basically what we wanted to share today. Thank you very much.
Thank you very much. Thank you very much, Lisa, Juliana. Okay, with this, we finished the country presentation for the morning, but we can have a round of questions. We have some questions online, but I don't know if you also have some questions to address to those who presented today. Yeah, of course. Daniel and Silvia.
Yeah, so two questions to the Dutch and the German presentation. The first one, maybe also to the other. The first one is, are there standard clauses that you discover in the company collective agreement? Because both of you said that you check mainly company collective agreement. So I wonder if in this agreement there are standard clauses that you kind of that you can reproduce in other company collective agreement, or that are already reproduced in other company collective agreement. And the second question concerns the sector, because actually in our three presentation, the banking sector and also dance and theater, so audiovisual sector, that were very, very present. Therefore, the audiovisual, it was a discovery. I didn't expect, actually, when we found this collective agreement, we were very surprised. And I don't know, maybe because of the Hollywood movement, can be that. But my question is, according to you, the agreement in this sector have been influenced by the collective agreement already present in other countries. So was there a kind of cross-fertilization or not? Because actually Maria Grazia and me, I don't know, Maria Grazia, then if you want to say something more, we couldn't discover if this audiovisual collective agreement was really developed because of Hollywood, because of Germany or Netherlands, but it was strange for us to discover this advanced collective agreement because it's the most advanced.
My question is for the two countries. I was thinking about the bank sector. And I would like to know if you see any kind of relationship or impact from the European agreement. Because I'm wondering about the causes of this regulation. For sure, this sector is very, very affected by digitalization. So it is a need to regulate these particular tools. But on the other hand, regulation is and these kind of agreements have their influence. So I would like to know if there's a sort of mixed or if the agreement is clearly the cause of these national regulations. Just to know your opinion.
I'm just going to follow up with two questions we have online for the Dutch team. So for Juliana and Lisa, one, whether the agreements on training and education include individually enforceable rights. So whether people can enforce the right to training or whether it remains rather vague. And second, just whether the agreement with Albert Heijn Logistics is a collective agreement signed with the FNV. The clause mentioned for Albert Heijn Logistics is part of a collective agreement signed with FNV. That's questions online.
Okay, so the floor is yours.
Yeah.
I guess Sylvia's question was actually also.
Who wants to respond?
Yeah, who wants to respond? It was for. Yeah.
Nele first, you respond to Sylvia's question?
Me?
If you want.
Okay,
If you
yeah.
can.
Well, I'll just give it a try and everybody else can just compliment me. Just for the first one, the standard clauses in company agreements. My part was mostly the collective agreements, and Christina was mostly responsible for the works agreements, so maybe she has something else to say about this. I would say actually there are few standard clauses. There are some which have been established for a longer time, which is mainly what comes to mind at first is the prohibition of an automated control of performance and behavior of employees, which is present in almost all of the agreements, also, for example, on remote working. But besides that, I found actually that the agreements, the works agreements that actually deal with artificial intelligence are quite company specific, which might also be a characteristic of AI introduction to the specific needs of the companies, making it also necessary to regulate it very specifically. Then on the international influence, possibly on the collective agreements in the film industry, I'm not sure, I have to admit, because the agreement came up after we finished our draft report, and I have not yet looked into it more fully. And then I think the last question was, if I understood it correctly, if there was an influence by the, or at least that's what I understood, the sectoral the sectoral agreement in the social dialogue at European level in banking, if there was an influence of that agreement on the agreements at national level or company level.
He's nodding, yes.
I just know that the responsible person in Germany for sectoral collective bargaining in banking on the employer side is very active in the sectoral dialogue. Oh no, I'm sorry, I'm mixing up insurance. So putting this together. So there might be an influence via a personal connection. Other than that, my personal experience is that such European agreements don't have too much influence in national bargaining in Germany. But as I have said, others may add. Thank you.
Thank you very much. I would now maybe ask Lisa and Juliana to respond, because lunch is being served, and then if Sylvia and still wants to say.
Okay, so I will answer the question regarding are there standard clauses that you discovered in the company collective agreements? So indeed, when specifically talking about AI and AM, the only clause that we could say was standard, but standard with considering the small amount of agreements, was with regard to intellectual property. So there were 3 agreements on the creative sector that regulated the matter of how the creation of voice recordings of recordings of music or artists in the dance and theater sectors, how this should be regulated in line of the AI and its interference in the creative sector. And then more broadly, when talking about technological changes, it could be more generalizable that there were clauses regarding training and education in different sectors and information and consultation rights with regards specifically to fear of redundancy. So in this case, when there is a risk of a job loss or quality of the work being affected, then there should be information and consultation and the role of trade unions and works councils highlighted. And then with regards to the question online, if there are agreements to in training and education include enforceable rights, well, indeed, we did find this. For example, it wasn't just general clauses, but they established specific rights for workers, like personal budgets that were devoted to to training AI skills, or like we saw on the last one, AI skills development had to be covered by the cost by the employer and during working time. So they were enforceable in some occasions. Thank you.
Yes, thank you for your questions. The last one is the simplest. It was also signed by the FNV, the largest trade union in the Netherlands, about where the inspiration for the provision came from. I think it's a very good question. And we also thought that the more the developments outside of the Netherlands would have inspired also like the content of the provisions. But when we interviewed the trade unionists negotiating, these were not mentioned. So that's interesting. The banking sector, for example, no mention of that agreement. This unionist was involved in other EU level agreements in the services sector. That was mentioned, but not the banking one. In the creative sector, also, it was more inspired by the issues that were raised by the members of the Arts and Culture Union that approached the union with issues surrounding intellectual property rights, plus the fact that, for example, voice actors are getting unemployed because of AI technology. So there's a clear impact already from AI to be seen in the sector. So those were the main drivers for the union taking it up as an issue. But in terms of what they put in terms of the text, yeah, they didn't mention inspiration from the other countries. So that's an interesting point, I think, that's raised. Thank you.
Thank you so much. Then, conscious of time, Sylvia, I would give you a final point to. We will give Maria Grazia a final moment to respond. Thank you so much.
Hello again. So I would like to answer regarding the influence of the European social partners agreements in the financial sector. Concerning Italy, the agreement specifically recall those joint declarations. They are attached to the agreement, so they, at least formally, are part of the agreement, and the parties are must fulfill the principle of the European Social Partner Declarations. So we are not able now to say if it will happen in practice and how, but at least formally, the two declarations have played a role in the finance sector in Italy. Sorry, here.
Thank you very much, Chiara. Grazie for the clarification. Okay, with this, we can close the morning section. I want to thank everybody, all the speakers and the audience for being here so long, and Angelique and Laureen for the support. And well, thank you very much. See you, I will say, at 1:45. Okay, thank you. Thank you very much, everyone, for being back. I hope you had a nice lunch break. And now we continue with the remaining two country studies, Poland and Spain. And we give the work to the Polish expert, Karol Mudzinski and Marta Otto. Thank you very much.
Do you hear me? Or should I? Everything's all right? Okay. Yeah. So we turn over to the Polish case, and unfortunately, we don't have very much to report in the Polish case, but we have a lot of explanations on why we don't have very much to report, which unfortunately mirror many of the discussions about collective bargaining in Central East, which probably many of you have already heard many times during such events. Let's start with the general description of the industrial relations system in Poland. And these are described as undergoing near-death experience, unfortunately. So we have a very low but relatively stable trade union density, very low collective bargaining coverage. Collective bargaining also happens mostly at the company level. And what is unfortunate about these collective bargaining processes is that they are also minimal in terms of what is being bargained for. And in particular, we have virtually no wage bargaining in Poland. So wage determination is something that is almost always decided in individual negotiations with the employer. There are some exceptions, but as I said, they are very minor. However, what has been historically happening in Poland is that the weak industrial relations have been compensated by the government with statutory protection, so basically with legislation. However, and this is also described in the literature, this statutory protection somehow crowds out collective bargaining. So legislation is very often so detailed that there is very little for the social partners to bargain for. As a result of that, trade unions are also focused mostly on statutory legislation lobbying. So because these collective bargaining processes are weak, trade unions and primarily main trade union center are much more focused on kind of lobbying for introducing new statutory regulation rather than on collective bargaining itself. However, and that is unfortunately the history as well, the statutory legislation is not necessarily properly enforced. So as a result of course, also the weakness of trade unions that serve as the main actor that is actually capable of making the statutory law enforceable. And what we have seen in Poland is that there have been various hopes expressed towards revitalization of industrial relations associated with many different developments, such as Europeanization of social dialogue, and recently with algorithmic management and AI. Okay, so we move forward to the adoption of new technologies at workplaces. So Poland is a pretty interesting case in the sense that In general, for instance, public administration is highly digitalized. However, what we see is that the implementation of new technologies used to manage workforce seems to be still pretty low. This we can explain by the domination of SMEs, right, that have lower level of digital intensity, less investments, rather low use of AI to manage workers. And in particular, what seems to happen is that there is some AI adoption at the workplace level, but it seems to happen mostly at the mid-managerial level rather than from the top. And what is further happening is that we have very limited to no AI or AM implementations in public workplaces. There are some programs at the ministries, for instance, but those are nascent. And publicly known adoption of algorithmic management and AI at workplaces is limited to the usual suspects, so logistics and platform work. So what are the challenges associated with these developments? And this will also allow me to highlight some of the problems that are relevant for the discussion of collective bargaining developments. What are the challenges associated with AI-AM adoption? The first one is exacerbated fishing. So Poland has been historically known for excessive use of non-standard forms of employment, including self-employment and civil law contracts that are basically kind of normalized in terms of their use. They can be used in situations that are very similar to employment contracts. As a result of that, government has also compensated for that with introduction of some protective mechanisms for these non-standard workers, including, this is a result of constitutional court ruling, but including 2019 law that granted the right to unionize to civil law contractors and self-employed, which is, let's say, a progressive solution, but at the same time, it is not met with a proper action in terms of unionization of those non-standard workers. The unionization of non-standard workers is very limited. AI can also exacerbate employment outsourcing, particularly since we are in a situation where basically Polish law allows for almost virtually limitless employment outsourcing. So we have even a situation where we have companies that are effectively operating as temporary work agencies that are not subject to temporary work agency regulations, and this is facilitated by these non-standard forms of employment. And we can imagine very easily that through the integration of AI and AM, company can very easily control what is happening outside of it in the companies to which the work is effectively outsourced. Further, there's a risk of increased managerial discretionary power. So a very simple example is the fact that we don't have wage bargaining, and we have extreme discretion in wage setting. So for instance, a huge percentage of regular Polish employee wage is discretionary. So it's paid through bonuses. And of course, there are kind of threats associated with job losses that are also expressed by the trade unions. So in terms of trade unions' perception of the issue, it seems to be mostly actually related to potential job losses. Okay, so how we have approached the data also reflects the fact that we have found very little. So we had to do careful analysis of what is happening in Poland in order to prove that there is nothing, right? So we actually used very different methods as a result of that. So first, speaking about data limitations, we have very limited, unfortunately, access to collective agreements, apart from multi-employer collective agreements that are publicly available at the ministry. Unfortunately, in paper form only. It's only right now digitalized. And we have no data and no research on digital fishing in Poland, which is challenging everywhere. So the empirical basis for our paper are all multi-employer collective agreements that are publicly available at the ministry. There are 175 of them. We have also inquired labor inspection, made trade union centers, employers organizations, and around 150 sectoral company level trade unions about collective bargaining developments, and there was very little response from them. We've conducted 9 expert interviews, mostly in companies known for adoption of new technologies in management. We have also reviewed something which is called Monitoring Social Conflicts Database. So our Ministry for Labor collects information about strikes and also unofficial actions of workers. And this is called monitoring social conflicts. It's a very comprehensive database that covers a period between 2022 to 2025. We have reviewed all of this in order to see whether something is happening with regards to sort of workers' response to AI and AM. And we also followed up on other secondary data, such as news reports. And I leave it to Marta. Okay. Still one slide. I'm sorry. So just what we have reviewed in terms of legal framework. So we don't have a separate AI regulation in Poland, although we have an incoming implementation of AI Act, of course, and Platform Work Directive, potentially. So we have reviewed a Trade Unions Act that regulates union operations and collective bargaining, labor code, and also various regulations that implement GDPR, remote work regulations, and other forms of monitoring that are relevant for AI-enabled oversight. And the purpose was to assess how the legal framework kind of facilitates or limits trade union capacity to negotiate in the face of adoptions made by the companies. And now I leave it to Mark.
Okay, thank you, Carol. And sorry, I'm going to reiterate the main diagnosis, which, by the way, is very repetitive in the Polish literature, namely concerning the Polish labor regulatory framework, which presents a paradox, right? Because it's so detailed that it effectively restricts meaningful collective bargaining in workplaces, even with strong unions, but also the same regulations are either poorly enforced or inapplicable, especially in workplaces where non-standard employment is used, or where we have loopholes that allow employers to bypass collective bargaining, which is, by the way, the case of remote work scenarios, and I will explain it later. Of course, the phenomenon mentioned by Carol, the phenomenon of fissuring, further undermines the workers' ability to effectively engage in collective bargaining. And to provide clarity and proof, just consider the following, right? So there are no sectoral collective agreements in Poland. From the multi-employer collective agreements, most of them, they remain pretty much stagnant since 2014, with no provisions concerning AI, AM, only two addressing remote work. And unfortunately, at the company level, the situation is pretty much similar, which means that while certain digitalized workplaces may have unionized workforces, the collective agreements are absent, and there is no regulation of fissuring, right? So there are no limitations on outsourcing, no limitations on subcontracting, and non-standard workers are often left without adequate protections. And even where remote work is being referenced in this company-level collective agreements, they mostly replicate statutory law. And now you may wonder, why is that so? Because the answer is pretty much simple. We have so detailed regulations on remote work in statutory law that, well, trade unions, they take it as a kind of safe regulatory ground and a point of reference, right? What is interesting is that this specific, under this framework, it is possible, or to put it differently, employers are required to consult trade unions or employee representatives before introducing remote work, but in practice, it does not work like this, right? So what is also interesting, we have pretty detailed regulation on digital monitoring, so the standard component of remote work, with strict statutory limitations, but those limitations are applicable only to standard employees and not non-standard workers, so another gap in the regulation. But again, because of very detailed statutory framework, the remote work is really scarcely addressed in collective agreements. And in most cases, remote work is in fact regulated via an alternative method, that is remote work regulations that should be consulted with trade unions or workers' representatives. But well, the practice differs depending on the sector and also on the strength of the trade unions. And there is a more balanced approach observed in the public sector, while in the private sector, well, again, it very much depends on the strength of the trade union. The banking is a positive example how it could be done in practice. When it comes to algorithmic management, this is another area that is that has begun to be regulated in Poland. But what is problematic is the fact that we regulated basically via implementation of Article 88, which frames the whole standard in a very individualistic manner. And we use kind of old provisions also concerning evaluation processes with some limitations stemming from general principles like respect for personal rights, equality, and non-discrimination. AM is not present in collective agreements, which means in fact that AM that is most often employed in workplaces with non-standard workers, such as platform workers, they operate without the safeguards that would apply under the statutory regulatory framework that is addressed to standard employees. And this situation generated a significant labor unrest, and we've put some examples here. We had conflicts in Amazon, Takeaway, Glovo, Volt. And what do they have in common is that, well, they managed to attract the attention, the public attention to the problem, but in fact, they were super limited in practice as such. So coming in a fast and furious manner to conclusions of our new results of our research, it is pretty obvious that the Polish economy lags behind Europe when it comes to integration of AI and AM. And this is problematic because this impact is still unfolding, which makes the trade unions' perception a bit different than in other member state countries. They tend to perceive the job displacement and related problems more as a looming challenge rather than an urgent issue that needs to be addressed now. The super detailed statutory regulations limit negotiation space, and employers, they do bypass unions through non-standard employment or remote work arrangement. And the problem is further compounded by the lack of a proper, or to put it differently, a weak role of tripartite bodies, which often so far are being used to react, to act reactively to some kind of external pressures, which is mainly the Brussels, rather than taking like a more proactive stance that would mean also strategic thinking about inventing proactive labor policies. So what is pretty obvious to us, especially listening to all of you, is that Poland is definitely missing or is a need for a new regulatory framework that would be less inspired by the GDPR and individualistic narrative and more by collective workers' rights. And there is a bit of ray of hope if you look at the legislative pipeline, because we are thinking about how to implement a directive on minimum wages, where there's a kind of tangible pressure to boost bargaining dynamics. And we have some ideas. So first of all, good news for researchers. There is a high chance that we will have access to a national register of collective agreements. There is an idea to introduce something that is inexistent in Poland, so the fixed term agreements that would encourage more often employer negotiations. And another opportunity is created by the platform work directive, but this is also a risky opportunity, but because if it won't be done carefully without broader systemic reforms, it could create kind of unequal protections for workers and paradoxically this time for standard workers who would not be covered by more progressive information consultation rights and so on that are introduced by the directive. So in conclusion, Poland is in desperate need for a more systemic reforms that would introduce more equitable standards. And what is kind of surprising is that for a longer while, we are looking for a Spanish example when it comes to all the parliamentary committee discussions on how the future regulation could look like. So it looks like a pure coincidence today could generate a kind of a déjà vu perception of you once we meet in 2 years, and you will hear a different story from us that would be highly inspired. I mean, it's highly probable that it's going to be inspired by the Spanish example as such. So perfect match. Thank you very much.
Thank you very much, Marta and Carol. Yeah, now we have the Spanish case. Daniel, and I see Sander also online.
Yes, I don't know how you can all hear me, right?
Yes.
Okay, perfect. I have no idea if I'm on the screen somewhere there or something.
No.
Just to ask, I suppose that Danny's going to do the slides, right? Because he's there.
Yes.
All right, perfect. So maybe because I'm opening, just to tell when to switch the slide.
I think that if you say next, Daniel can click.
Perfect.
He nods. Okay.
Here.
Okay,
All
and the floor is yours.
Thank you. Well, just starting, thank you everybody for the organization. And inside, it's really sorry I cannot be there, but very interesting to hear everything. So I will just starting with the first point to tell something about the state of AI and AM in Spain to complement the data previously presented, for example, by Wouter and also the other countries. Well, there is a lot of data on this slide, but just those things that have caught our attention. For example, if we check that, if we consult the number of companies, the percentage of companies that are using AI, it's currently on 12%. Like also the other countries, it goes up when we look at the ICT sector, followed by service and industry. Then what's also, I think, interesting for us is that when we ask about the functions, then the function that comes out is cited the most is AI for business administration or management processes. And then also when we look at why companies wouldn't use AI, then what's also, I think, very interesting is that they also concern about data protection and privacy violations. Like 40% of the companies that say that they have considered using AI said they didn't because of those concerns. But the most concern that they cite is the lack of relevant specialized knowledge. So that on the state of AI in Spain, maybe we can then go to the methodology that we use for constructing the database, which is, it's a few slides further. All right, so here. So just very quickly, how did we select all those collective agreements, for instance, that are in the database, but also on which the chapter is built and based? Of course, we've briefly both haven't been in projects already on this topic. We had the database of the ETUI, but I think that the main source for us was the database provided by JURGT, which is one of the Spanish Mediterranean unions, together with Comisiones Obreras. They provided us with a list of collective agreements on digitalization. What we did is that me and Danielle, we checked one by one all the collective agreements that were there. We have in Spain, we have to look that all those collective agreements are publicly available. So it's just a question of looking at them and see to what extent digitalization is covered or addressed. What we did internally is that we checked for each collective agreement to what extent AI is being addressed, because as you might recall from the first phase, there were like different priorities. Main priority might be AI and algorithmic management. Also to check if remote working or right to disconnect was also addressed. So we internally labeled to that. And if you can go to the next slide, Danielle, then we can see that this is more or less the result. Like AI is in algorithms is being specifically addressed, but most teams are just like for the other countries also remote working, data protection, and everything that is not AI but still related to digitalization. So far about the methodology. And now Daniel will have the word on the collective bargaining patterns.
Okay, thank you, Sander. So based on this methodology, I would like to focus on, first of all, the regulatory framework, I mean, the legal one, and then focusing on the some of the 7 collective agreements that Sander mentioned. Concerning the regulatory framework, I would say that there's a clear trend that is common to other fields concerning digitalization. First of all, the prehistory, in which case law is clear, crystal clear. Here I'm mentioning 2 Supreme Court judgments solving cases in which AI was used in order to decide who's going to be dismissed in cases concerning collective dismissal. Particularly in these 2 cases, the Supreme Court found that the use of AI was not illegal, or it was not affecting discrimination or other kinds of fundamental rights, because the reason was completely objective thanks to the use of the AI. Maybe these cases nowadays were solved differently by the Supreme Court, because at that time, 2018, the knowledge concerning AI were completely different to the current situation. Then, after the beginning, thanks to the court's action, we have the first legal reactions, the Riders' Law, the 2 sides and the sides that we are using now, that is applicable all over the economy for all sectors, is the one introducing the possibility of informing concerning the AI and algorithmic management as well. And here I would like to highlight also the ministry's guidelines, that it was a very useful tool provided by the Ministry of Labor, prepared by some scholars and some other experts, and that I think that it was useful in order to help companies to negotiate the first collective agreements. Actually, then I'm going to highlight how the negotiators are asking for additional administrative help. And then obviously there are other laws, such as the organic law on data protection, administrative instructions concerning data protection, in which AI and algorithmic management is also related, so we can obtain also regulation from that. And now the current situation is that we have 2 draft laws, one at the national level and another one for Galicia, one of our autonomous communities. These 2 draft laws on AI are not focused on regulating rights, but the subjective side, I mean, the administrative subject that are in charge of controlling and sanctioning the use of the not well used of AI. So it is a complement for the AI Act. And here I would like to highlight that in the case of the national law, there's a current issue that is being negotiated because the labor inspectorate is not included. It is included the National Agency on AI that was created 2 years ago. It is included other national authorities, such as the data protection, the Personal Data Protection Agency, others such as the ones concerning the judicial power or the legislative power, but the labor inspector is not still there. So hopefully during the negotiations, the labor inspector is introduced because they have the resources also for implementing the AI regulation. What about the collective agreements? Here I'm highlighting 19 collective agreements, more than the 7, because there are others mentioning AI. We are focusing on the ones that are regulating AI exactly. And the point here is that in the case of Spain, and this is that I think that is shared with other countries, the national law or the national regulation is promoting the collective agreements. In the case of the telework, that was a former issue. Now the collective agreements on telework are huge, more than 700. The same in the case of remote work or the digital disconnection. So the trend will be that the AI will be, the number of collective agreements will be increased in the future for sure. Some examples concerning the regulation of the AI. Here I'm showing you the 5th agreement, the framework agreement on collective bargaining, that is giving some instructions, suggestions, measures for all sectors. In this slide, it is highlighted that it is necessary to introduce the information and consultation procedures. And also it is highlighting that collective agreement negotiators must pay attention to 2 different gaps, the gender gap and the age gap as well. This framework agreement also pay attention to the learning, training, investment in skills. That is also one point that was highlighted in other countries previously. And the last point that is introduced in this framework agreement is setting different criteria in order to assess how the information and consultation is provided. I mean, it is not only necessary to introduce information and consultation, but also the issues, the topics that are going to be informed and consulted. And here the point that I highlighted previously, there's a call to the public administration to continue supporting the activity of the negotiators. Aside the framework agreement, we have some collective agreements. For example, this one concerning the banking sector. There are some articles, such as the one that I mentioned at the beginning, that are related to AI as well, such as the right to disconnection, the right to privacy in different areas, etc. But I would like to highlight or to focus on the right to artificial intelligence. Here, what we have is, on the one hand, some rights that are previously recognized by laws, such as the right to not to be subject to decisions based solely or exclusively on automated variables, the right to non-discriminations concerning the use of this kind of mechanism in different areas concerning working conditions, and also the right to participation and intervention of the persons designated for this purpose by the company. That is, not only the workers' representatives, but also the workers themselves. And concerning the right to information, it is not only concerning general issues, but also the use of data analytics or artificial intelligence, and when are based exclusively on digital models without human intervention. This is also previously recognized by law, but also included here. In the case of the financial credit institutions, the article is very, very similar to the previous one, so I'm going to skip from there. And here what we have is the article 47, focus on digital transition in the collective agreement of fruit trade in Coruña. And here the point is the list itself. So the right to information is recognized when the AI is used concerning this list of working conditions. So what we have here is the mixed in between not only the use of AI, so when the AI is used for different purposes that are the classical one, hiring, firing, salary, etc., etc., etc. The collective agreement for the chemical industry. Here we have different areas, different tools concerning artificial intelligence. First of all, not only information, but also consultation concerning the use of AI, and before that, the evaluation, the assessment concerning the future impact of the AI. In this case, the collective agreement also guarantees training for the negotiators in order to be ready to negotiate, to assess that future impact. Second, concerning information during and after the implementation of AI, here we have the list of questions that are included, the whole procedure before the implementation, during the implementation, and after that, and also setting details concerning the information that must be provided, parameters, rules, and instructions on which AI algorithms or systems are based. And also, in this case and in this collective agreement, worker representatives will be able to issue a report with observations concerning the implementation, the new implementation of AI. So before the implementation, there's not only that right to be informed, but also the consultation, the possibility that workers' representatives are going to say what they think about the potential impact of the AI in this particular sector. And this includes not only general working conditions, but also occupational risk assessment. And this is another issue which must be guaranteed in that evaluation, that is the guiding principle of human control, that is not new, but is introduced in this particular point in the procedure of the implementation. And finally, a quite old collective agreement, 2021, but we wanted to highlight it, and I'm finishing with it, because it's the most important one concerning the company's level, the adjusted collective agreement. Here you can see different rights that are recognized even before that the law introduced these new rights. And I would like to focus on the information rights, in which different parameters, concrete parameters, were introduced. I must insist on it, even before the riders' law. And the key aspect here is at the end of the slide, that is the creation of the Algorithm Commission, a commission formed by workers' representatives and companies' representatives in charge of receiving that information, in charge of analyzing that information, in charge of assessing how the algorithm management is implemented, and also to find solutions in case of any kind of risk is found. And that's all, because I'm out of time. Thank you so much.
Thank you very much, both Sander and Daniel. Okay, that was the last of the country presentation. I think we have a lot of complementarity, overlap, and gaps. But before going to the concluding remarks, if there are specific questions related to this to presentation, actually in the chat we had some questions for the Polish speakers. Yeah, which now we'll find. But the first one I actually noted, so perhaps I can go with the first, which actually a participant is asking if you can give an actual example of very specific legislation on digital monitoring in Poland, because you were mentioning that there is this overcrowding legislation and there is no space. So perhaps that. And there was another one.
Yeah, there was a second question as well, but that's quite a detailed question on Article 88 GDPR. Maybe we'll just ask the Polish colleagues to have a look. And
yeah, maybe this one.
Yeah.
Okay. Sorry for that. So when it comes to digital monitoring, we have pretty much detailed provisions concerning video monitoring, the monitoring of emails, and extension of this kind of provisions and procedures to the so-called digital monitoring or other forms of monitoring that we call digital monitoring, which could be also AM, AA based, etc. The problem with this provision is that they provide, well, strict limitations that are based on a very general clauses like digital monitoring can be introduced whenever it is necessary for guaranteeing adequate use of for organizational purposes, right? So time-wise and the proper use of working tools. I'm trying to translate at the same time from Polish in my head. And then we have kind of interesting procedures. So those, the scope and the goals. So in fact, the proportionality principle under the GDPR can be introduced either via collective agreement or work regulation or the so-called notice, which is, by the way, the least formal way of collective notification of workers of changing working arrangements. But in practice, this digital monitoring, it is not being introduced via collective agreements because of all of the reasons mentioned by Carol and me. And most often it's either work regulation or even a notice. So in fact, it's pretty much introduced unilaterally. So it's, I mean, this is the strictness, but at the same time, this provisions leaves a margin of maneuver for employers to in fact introduce a certain standard without properly consulting workers' representatives.
Thank you. I think it's a full question. Perhaps you can reply.
Okay, I will read it loud. Okay, this one, right? This one. On limited personal scope of application of statutory legislation, any chance that the case might be brought in front of the CGU, who would then need to decide on the personal scope of application of Article 88? How do you estimate would argue in favor of a broad scope also covering Polish civil contractors?
Yeah, perhaps you can reply. Perhaps that one.
No, that's a tough one. That's a tough one. Well, I would need time to think about it because it's a pretty complex question in many different dimensions. Also having in mind the still relatively recent judgment of the Court of Justice concerning the German regulation, which was considered as not specific enough, right, by the Court of Justice. So there are many different layers. So sorry for not responding immediately, but well, give me some time. And if you feel like, please contact me via email that was made available.
Thank you very much, Marta. Unless Carol want to add something, there was a question again in the chat for the Spanish expert. I don't know if they have a chance to read it, but you can also take advantage of the chat to reply to the question. So in case you, if Silvia has another question.
Yeah, actually one question, thank you very much for the presentation. One question to Carol and Marta. You said that Amazon in Poland use an algorithmic management system in order to determine the wage, but this was blocked. And why was it blocked? What was the problem? So what was the law that was enforced against this kind of wage determination system? And to Sander and Daniel, the question is, so you present several collective agreement, national, provincial, and company collective agreement. Question is, the national one, are they erga omnes, and who are the signing parties? And since the clauses in the agreement, at least to me, they seem quite advanced, quite developed. if there are also practices of a negotiation of the algorithmic management. So once the trade union get this information, they are consulted, are they able also to negotiate the use of these artificial management tools or not?
Yeah, just to clarify the last question, you mean from a technical point of view, if they are ready to, okay.
Yeah, so I can start. So the reason why the wage determination by algorithms was it was suspended indefinitely, actually. So it's not like I believe that it's. I would have to check the interview, to be honest, but I believe that the way in which it formally works at Amazon is that they have indefinitely suspended wage determination by algorithms as a result of trade unions opposing that. And it's like a very strange situation, meaning that they said that they are not removing that, but they have suspended it, I think, in 2018. And yeah, it's not been applied afterwards. So yeah, it's just as a result of union mobilization. That's it. But still, AM is still being used, but not to determine wages. So bonuses are not determined with the use of algorithms, but still AM is being used to review workers' performance criteria. To some, like unions believe that to some extent to promote workers, even though this is not explicit. And the situation, I think, is very similar to other countries, meaning that it's pretty ambiguous where exactly and how algorithmic management is being deployed. So some of the things are kind of deciphered by the unions and are made explicit by the management, but not all of them. And still unions believe that there are some components of algorithmic management that are not explicitly taught to the unions. So this is how it works.
Thank you.
Concerning the questions, maybe we can start with the second one, just in case Sander wants to add anything. I would say that in the case of the trade unions, they are doing a huge effort in order to be ready for the negotiation of the algorithm management and AI. As far as I know, both the two main collective agreements, Comisiones Obreras and UGT, have their own guidelines concerning the negotiations. But I would say also that maybe this is not enough. We all know that this is a very complex issue, that even we are working on it every day, and even we have a lot of doubts concerning what to do. And the additional help of the public administration, and that's the reason because I wanted to highlight the ministry's guidelines, is also a key issue. And actually, as I've mentioned in the slides, the framework agreement is asking for additional help on this particular issue. And the public administration has its own resources and technical tools and support to do that. Sander, before answering the first question that is only legal, do you want to add?
Well, just also complementing, but precisely what Daniel said, and also I think that now I'm talking about previous research experience which we had in another project called Encoding. That one thing is also to have it in the collective bargaining or even in a regulatory framework, because at the moment Spain was, if I recall right, one of the first ones to implement such an article. But then when we went to the level of the companies, then it was still quite hard to turn all the rights that they had into to make them effective, so to say. So I don't know if that answers your question. I mean, it's really to cover the experience that would require another methodology, which would be talking to all those that have those instruments. But yeah, that's just to complement Danielle. And then there was also another question, but I don't know if you want to answer that on the chat about
perhaps that question, not all of us have a laptop in front, perhaps that question you can reply directly in the chat.
All right.
If you want, if you'll feel up to, because for unless you want to further add to the question of Silvia, we could pass to the concluding remarks.
Concerning very quick the erga omnes effect, generally speaking, the erga omnes effects is the general rule. All collective agreements that are signed by UGT and comisiones, that they have the level of representativeness that is required by our work statute, means that that collective agreement is going to have the erga omnes effects. Consequence, both the national one and the provincial one that I mentioned on the lines, both of them have erga omnes effects.
Thank you very much, Daniel. And with this, I think we can wrap up this session. We have a couple of final slides that we can show you, where Wouter and I, on the basis of the written reports, try to extrapolate some common dimensions. Now it's a bit awkward because we are going to walk there.
In slow motion.
And yeah, it's going to be fast.
So first of all, let's thank everyone again who participated online and also everyone here in the room. I think it was super interesting to see the different country chapters. I think it's also, it will show to what extent I might have missed the mark a little bit in some of the summaries, but this is very good to get feedback on. And it's a little bit to discuss the sort of themes we see coming out of the written chapter reports, which are even richer than what was presented here today. But we just want to start by thanking everyone who was attending online, who had questions and participated, and also to all the speakers. Thank you so much. So to wrap up, we were thinking a little bit about what sort of cross-country lessons we can draw from this, what sort of aspects come out. And we saw several axes or thematic clusters that we think are important, on which we see difference between the countries. First, the simplest one, the extent to which there is any addressing of artificial intelligence and algorithmic management in social dialogue. And there we see, here again, I've classified countries. You can correct me afterwards if I'm wrong or if you disagree. It's as a way to start discussion. So where there's hardly any action at all, we see Poland, for instance, which you've explained why there's little coming on in terms of collective bargaining. Then limited, here I put Belgium because there's limited action. Denmark is a bit of a special case, I think, because there is the action on the platform work and there are the rights of the representatives and of works councils to deal with this, but there's little found in terms of collective agreements. And then we saw countries where there was some more activities. What we also found an interesting axis is the level at which there is bargaining. And then we're mainly thinking, is this more sectoral or national or company-based? And linked to that, so we see in Netherlands and Germany, a lot came from company levels. And we saw a bit more sectoral or national level in some of the other countries. Linked to that, we thought it was interesting to have this variation between countries where the action was more from the bottom up. And then we're mainly thinking about sectors or company level agreements that start, while in other countries, and then I'm particularly thinking Spain, Italy, Belgium, much more when there was collective agreements, it was really coming because of regulatory change, legislative change. And I guess Poland would be in there as well with very detailed regulation. But then, of course, you have the special issues there. And then the variation between sectors, I think, is also interesting to explore. So these are a bit the themes that came up to us as particular things to explore further as we're doing the cross-country comparison.
Yeah, and when looking at emerging subjects, and this is something we enriched when you were actually talking, we saw, actually, this related to the question of Silvia, how many, if there are patterns, if there are like clauses that repeat themselves, and probably it's not because of cross-fertilization, but because of emerging trends independently, we find that all, with the exception of Poland, case study identified clauses on skills. So learning skills, training is always regulated collectively in relation to AI. We also find quite a lot of remote work, in this case, also in the polling case, a right to disconnect, but these are periphery clauses, I will say. Transparency, right to explanation are also present quite a lot. Privacy, data right. We have less tendency to find clauses on more substantial, let me say, more connected to working condition, such as actually procedure for the introduction of AI. So information and consultation procedure ad hoc established when new technology have to be introduced. We identify ad hoc procedure in Germany, Netherlands, and Spain, beside already general framework that other countries may have. Very interesting, we identify a few countries, Germany, Italy, Netherlands, and Spain, where actually the social partner identify prohibition to the use of AI and data processing. So what are the big gaps? What is missing? We think what is missing is establishing of redistribution mechanism for the use of data. And there, from what we understood, there was a very nice exception from the German case in relation to the creative sector, where they are banned from the use of data of creative sector workers to train AI. What is missing is also the extension of this clause to subcontractors across the supply chain, because fissuring is aggravated by AI, as Carol and Marta explained. And there is a partial exception in the Netherlands, because you found some agreement that also extend to subcontractors, so temporary agency works. And also what is missing is actually using the digital ecosystem, the potentiality of AI to foster trade union organizing and workers organizing. In that, we find an exception with the digital hub in the Danish case. So there are a bit of exception, but they're generally missing trends. So with this, we would like to conclude this webinar, the part of the workshop that is streamed online. These are the preliminary funding. More will come out in a volume, and will be probably partially corrected in a volume 1 of a book project, will be out in the first half of next year. So thank you very much for all those participated online, and now we can close the streaming.
For the participants, they have to...
And for the participant,
yeah, there's a different link.
There's a different link. Okay.